Good morning, ladies and gentlemen. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, February 24th, 2026. My name is Deborah Dryden, and I'm chair of the board. Board members, please go around and state names for the record.
Marshall Williamson, Hamilton Court, Kevin Shea,
Amy Wing Eastside.
Also present are Solomon Fortune, our zoning administrator, John Kinley, senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, clerk to the board, Therese Hagler Gray, senior assistant city attorney and advisor to the planning staff, Paige Inman, assistant city attorney, advisor to the board, and Elizabeth Majors, Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions, like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base your expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific special damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right to any ex parte communication to be disclosed. Ex parte communication is any communication about the place outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by any affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witness provide testimony. The board and city staff may question the applicant and their witness. Other parties wishing to speak for or against the case will be given reasonable time to present sworn testimony. The staff and the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or appeal. In case of an appeal, the chairperson calls for a motion and a second to uphold, modify, or reverse the administrator's decision. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain at the board. If your case is not appealed to Superior Court for 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. Okay. Swear in at the time the administrators for today, please, if you. All right, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you very much. Okay, all right. All right, we're going to open the evidentiary hearing. I mean, sorry, the defer. That's what I meant to say. I'm sorry, I'm reading this and thinking that. We have two requests for a deferral. First, variance number 2025-00050. For Queensborough Condominium Owners Association, they have requested a deferral till March the 31st. Do I have a motion?
So moved.
Thank you, Mr. Court.
Second.
Thank you, Mr. Shea. Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea, Ms. Sun,
Yes.
Dryden, yes. So that case will be deferred until March the 31st. The second case asked for deferred is variance number 2026-00002. Is for property located at 2962 Morning Drive. Do I hear a motion to approve the deferral?
So
Court.
motion.
Thank you, Ms. Sun. Do I hear a second?
Second.
Thank you, Mr. Court. Mr. Williamson,
Yes.
Mr. Court,
Yes.
Mr. Shea,
Sure, yes.
Ms. Sun, and Dryden, yes. So that is also continued until March 30th. All right, now, here we go. So we will now open the evidentiary hearing for case number 2025-00044. Property is located at 110 Honeywood Avenue. Before we begin, does any board member have a conflict of interest or potential conflict or any ex parte communication that needs to close? Okay. Ms. Kelly, you may begin.
All right, this is for Epic Realty Solutions LLC, represented by Nicole Imna, and located at 110 Honeywood Avenue, and it's owned by Epic Realty Solutions. They're seeking two variances from UDO Article 8.3C, Table 8-2, Row A, to reduce the frontage setback from 36 feet to 10 feet of Honeywood Avenue. And then a variance from UDO Article 20.9, Table 20-2, to reduce the required Class A landscape yard from 40 feet to 25 feet. So Exhibit 1 is our vicinity map. Site is up north of Uptown near the interchange of 85 and Brookshire. It's off of Roslyn's Ferry Road and Honeywood Avenue. Here's an aerial map on Exhibit 2 of the property, again located at the intersection of Honeywood here, Roslyn's Ferry here, actually the end of Odom Street, which used to continue through, but it doesn't anymore. Exhibit 3 is the zoning map. The property is on ML2, Manufacturing Logistics Zoning District. And this abutting property here, you can see just off the slide, I think it's into A or into B. Either way, this is a single family dwelling here, so that's why there's a landscape yard that's required against this property line that we'll talk about. This is a kind of outdated street view image of the property, Exhibit 4. It was being used for storage of vehicles and stuff, but I think that's actually actively being cleared out right now. The variance request is from table 8-2, row 8.3C to reduce that frontage setback along Honeywood from 36 feet to 10 feet. And Article 20.9, Table 20-2 to reduce the required Class A APR from 4 feet to 25. And the applicants have offered and agreed to a couple conditions for this variance request that all require plantings from zones 1 and 2 of Class A landscape yard will be provided within the reduced 25-foot wide landscape yard. So the width of the landscape yard and the width of the landscape yard would not be further reduced with a fence or wall if one is provided. And then the applicant would also provide screening shrubs in Honeywood Avenue right of way and the proposed development along Honeywood Avenue depicted on the layout plan, which we got. Here's Exhibit 6, just the standards from the UDO for reference. Again, there's a frontage setback along Honeywood Avenue for 36 feet. Oh,
I apologize.
sorry, technical issue with YouTube.
Okay. Sorry about that.
Thanks, Chris. So basically along Honeywood, measured from the future back of curb or existing back of curb, whichever is the greatest, the frontage setback requirement is 6 feet from the ordinance. And then landscape yard, a Class A landscape yard is required when you're abutting any other zoning district and you're in ML2 zoning. And then this is what the standards are for a Class A landscape yard. And so when we're talking about zone 1 and 2 planting requirements, we're talking about these requirements here. And they agreed to provide, again, all the plantings that would be required here just within a 25-foot wide space rather than the 4. And if you take a look at the plan, on the left in Exhibit 7 from the survey, you can see that if the area without variance is roughly 36 feet wide by 140 feet deep, that would be their usable or developable area of the property. So what they're asking for is to reduce this frontage setback to 10 feet, reduce the depth of the landscape yard by 25 feet, and that would increase the buildable or usable area of the lot to 61 feet by 159 feet. And then what that accommodates for them, just small 5-foot wide building on the property and some parking with maneuvering, driveway on and off of Honeywood Avenue, landscape yard abutting that residential property over here. Any questions about the plan? Not so. The note that they have in the plan is that there be a proposed evergreen shrubs at a rate of one per every 2 linear feet along Honeywood Avenue. So that's what we would be looking for in the condition when it says that they agree to provide landscaping along Honeywood.
So at the bottom, it says the shed. It looks like the shed is going to stay.
That's what needs to be removed because they are.
Right.
But those are existing there now, so that's why they're showing them.
Okay.
So essentially this had front, short end had frontage and now it doesn't, the frontage is on side street.
Well, because at the corner, it's frontage on both streets. So there's a 36-foot frontage setback along Bodum/Rossell's Ferry and Honeywood. The ordinance doesn't give you, for manufacturing logistics districts, it doesn't give you corner side setbacks like residential zoning does. So the frontage setback, and they're generally about the same, depending on the street classification. In this case, street classification calls for both frontages to have a 36-foot setback. And then along the frontage here, they also have this railroad right of way that actually goes further back than the frontage setback does, because this line here is the frontage setback line, and then this line is the railroad. It does not. It sort of touches Rossell's Ferry here, where because there's a guardrail. It's covered up by my label. There's a guardrail at the end of Odom there. So the right of way for Rossell's Ferry is kind of swooping here. So I think the corner here cut Rossell's Ferry. I'm not
sure. Matter to your qualification for fronting on both streets, you know? I'm just a little bit.
No, not for manufacturing logistics.
That's right.
So Exhibit 8 is standards for granting variance. Again, all four of these need to be met to justify granting the variance. And I'll give you a minute to look over the findings before I jump into those.
Hey, John.
Right, so unnecessary hardship results from the strict application of the regulations. The hardship is a result of the application of the regulations due to the size of the parcel. Again, per Table 8-2, Row A of Article 8.3, the frontage setback 36 feet is measured from the back of curve along Rossell's Ferry Road and along Honeywood Avenue. So you've got a 36-foot frontage setback along both streets. The per Article 20.9 Table -20-3, all development in ML2 zoning is required to provide a wide Class A landscape yard when abutting any other zoning district, and abutting property to the rear is zoned into B. Therefore, there's a Class A landscape yard required. Applicant's survey of property show that it's 12,598 square feet with a depth of approximately 210 feet and a width of approximately 53 feet. And the strict application of the ordinance reduces that developable area to about 140 by 36 feet, such that development of the site would not be possible. And variances reduce this Honeywood setback and landscape yard would increase that developable area to a dimension of about 159 by 60 feet, which will allow some development of the lot. Hardship results from the conditions that are peculiar to the property. Due to the lot's limited width and unique dimensions, the lot is significantly narrower and smaller than typical lots in an ML2 zoning district, making it impossible to comply with both the frontage setbacks and the landscape yard requirements and still have sufficient buildable area for a functional structure and off-street parking. Hardship does not result from that were taken by the applicant or the property owner. The owner and the applicant did not create the lot with the narrow width and small size, and the lot was purchased in 2021, and the purchase of the property with knowledge the circumstances exist that may require variance cannot be regarded as a hardship. And the requested variance is consistent with the spirit, purpose, and intent of the regulations. Granting the variance will allow the development of the lot. The size of the lot would limit the ability to develop the lot with heavy industrial uses. And the lot abuts adjacent other ML2 zoned properties with commercial and industrial zoning. The applicants have offered and agreed to conditions that would require all plantings from zones 1 and 2 of the Class A landscape yard to be provided within the 25-foot wide landscape yard, and the width of that landscape yard not be further reduced with a fence or wall. And then the condition provides screening between the proposed development and the abutting residential uses in zoning. And the applicants have also agreed and offered and agreed to the condition that screening shrubs will be provided along Honeywood Avenue, as generally depicted on the layout plan, providing screening of the use of Honeywood Avenue.
Is there anyone in opposition to this speaking to?
If anyone has not very many signatures on here, if there's. These guys around. The
Mr. Admin,
last slide, exhibit
will you
11 is
clarify
the
with the
photo of
audience
the
that no one's here in opposition?
All right, so you say no one is here in opposition?
If you want to pull the audience, I guess. I'm not aware of anybody here in opposition.
Board finds no one here in opposition to this variance request. Okay, John.
That concludes our presentation.
All right. More questions for John?
Motion to approve with conditions.
Mr. Shea, do I hear a second?
Sun second.
Ms. Sun, thank you. Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Yes.
Ms. Sun,
Sun, yes.
and Dryden, yes. So the conditions. All right, looking at the finding facts and conclusions of law. I hear a motion to approve.
Court moved to approve finding of fact and conditions of law. Conclusion.
Okay, thank you, Mr. Court.
Sun second.
Thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea, and Dryden, yes. So the variance is approved with conditions. Thank you very much. All right, our next variance is 2025-0049 for property located at 610 South Church.
All right.
Before you start, John, Crystal, would you step? Like, are you in?
Mr. Dryden, I'm going to recuse myself from this.
Oh,
So we
okay.
need to ask them if they proceed with 4 unless we got an alternate here.
All right. Ms. Beeson, Alex Ritz. Okay, let me do this. All right.
I think that Ms. Shirley is here.
Do you?
We have an alternate.
Oh, all right, just one moment. Okay. Do you solemnly swear to affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Crystal. All right. So on this item, Mr. Williamson recuses. We do have an alternate. Will step forward, please, and join the board. And if you will, please state your name.
Sure.
Janice Shirley. Thank you, Ms. Shirley. All right. Okay, Mr. Kinley.
All right. So this is variance case 2025-00049, GSLH Charlotte Realty Holdings, and represented by represented by Sarah Beeson with Alexander Ricks. Property located at 16 South Church Street, owned by GSLH Charlotte Realty Holdings. The variance is from the Legacy Zoning Ordinance, Section 9.9062B, to allow transparent windows, doors, and range so that the uses are from and accessible to the street on 34% of the length of the first floor street frontage along Brooklyn Village Avenue, rather than the required 50%. Exhibit 1 is the vicinity map of the property. This is at the corner of Brooklyn Village and Church and Mint Street. The zoning map is showing UC, Uptown Core Zoning District, but the plans for this project predate the UDO, and so they're subject to the Legacy Zoning Ordinance, which was zoned UMUD. The aerial close-up of the property is currently under construction. Again, there's construction fencing on the property on the core from the street view. Exhibit 5 is the variance request. Again, Section 9.9062B requires that 50% of your first floor street frontage has windows and transparent windows and doors, and the request is to reduce that to 34%. Section 9.9062B is the section related to street walls. In that first paragraph is where it talks about the 50% of the frontage, or the first floor street frontage. It goes on to talk about other things to consider. So in addition, a combination of design elements must be used on the building facade and in relationship to the building at the street level to animate and enliven the streetscape. Design elements can include, but are not limited to, the following: ornamentation, molding, string courses, belt courses, etc. Goes on. In the event that ventilation grates or emergency exit doors are located at the first floor, those must be decorative. If there's expanses of blank walls, then they cannot exceed 20 feet in length, and a blank wall facade which does not add to the character of the streetscape and does not contain transparent windows and doors or sufficient ornamentation or articulation is listed above. The first floor and street level must be designed with attention to the adjacent public or private spaces and existing streetscape improvements. The provision of multiple entrances from the sidewalk or open spaces is encouraged. Now, one of the things that the ordinance doesn't do is it doesn't allow you to basically utilize these other ornamentations, works of art, landscaping features, that sort of thing to do. It doesn't allow you to do that instead of meeting the transparency requirements, in addition to the transparency requirements. So in addition to the 50% clear glass windows, you're also expected to do all these things to enliven that pedestrian environment along the street. Exhibit 7 is a recombination plat, just showing the parcel. And we're talking about this section of the Brooklyn Village Street frontage avenue. And again, here's where we're talking about the site plan. This is north at the bottom of the page. So this is rotated 300 or 180 degrees from this dimension. Let's take a closer look at the elevation and site plan on exhibit number 9. So ordinance again would require that 50% of this frontage have clear glass windows and doors. And if you go by the strict application of that requirement, they're at about 34%. What they would like to do is allow that reduction to 34%. And they're, as a condition of the variance, they're committing to doing this landscaping and other pedestrian elements as a condition of the variance. So they would be providing the limits of the ground floor elevation highlighted above would utilize landscape screening elements as generally depicted, and in lieu of the required transparency requirements, the remainder of the project would meet the transparency. So they're meeting the transparency requirements on these ends here. This is the section in the middle that they're that requirement for. And that is, in large part due to the fact that this is where their vehicular access is from for both loading and parking. And we'll get into that when we go into the findings. Exhibit 10 is the elevation again, showing that along Brooklyn Village, this area, the area that's kind of where they're seeking that alternative design, allowing that landscaping elements and pedestrian enhancing elements to work in lieu of the our transparency requirement. If you take this area out and look at the transparency, they were actually at 64%. So they're beyond the requirements. If you look at this area and this area kind of as a on their own, but when you put it as a whole, they're 34%. Exhibit 11 is the criteria for new in order to keep it. And as already, I'll continue.
Do we have anyone here in opposition to this, John?
I don't know what's happened to the sign-in sheet.
Can we also direct that question to the audience just to confirm?
Is there anyone here that is in opposition to this variant present in the room? All right, thank you. All right, let's see. All right, John, you may continue.
Unnecessary hardship results from the strict application of regulations. Because the primary vehicular entrances and critical building functions have to be located along the Brooklyn Village Avenue frontage. The portion of Mint Street that abuts the site is closed intermittently. That's activities related to the Bank of America Stadium and events in uptown. And that's outlined in the applicant street closure schedule exhibit that they included in their application. Church Street is a one-way street and a major thoroughfare leading out of uptown. So Brooklyn Village Avenue is the only two-way street adjacent to the site that allows for uninterrupted access. Building functions such as fire pumps, transformers, generators, and other mechanical and service areas are accessed from the primary entrances as required by building code and ordinances. The combination of the street access and building functions dictated to the site layout results in the hardship of meeting the strict application of the ordinance the requirements because the service doors and mechanical ventilation are not made of transparent windows and doors. Although the applicant is providing landscape screening elements, the strict application ordinance does not allow for that landscaping to be used in lieu of the requirements for windows and doors along the 50% of the first floor. The hardship results from conditions that are peculiar to the property. Hardship results from configuration of the site, streets subject to the site access constraints, the building function and constraints that dictate the building design, and significantly impair the site's ability to satisfy the transparency requirements along the Brooklyn Village frontage. The portion of Mint Street abutting the site is closed intermittently for events and activities, and Church Street is a one-way street, major thoroughfare leading out of uptown. Brooklyn Village Avenue, again, is the only two-way street adjacent to the site with uninterrupted access. The hardship does not result from actions that were taken by the applicant or the property owner. The hardship results from the street access constraints and the building function constraints as shown on the applicant's plans and elevations. The requested variance is consistent with the spirit, purpose, and intent of the regulations. The requested variance would allow for reasonable accommodation for the property owner to comply with the intent of the ordinance considering the site constraints. The requested variance is the least possible deviation from the ordinance, and the requested variance is the only avenue for relief from the hardship. The requested variance would not substantially detract from the character of uptown. The remainder of the site exceeds the transparency requirements, and the proposed enhanced streetscape further supports the intent of the transparency requirements to encourage and complement that pedestrian interest and activity along Brooklyn Village frontage. Approval of the variance supports public safety by allowing building access functions to be designed to address the site's constraints, and the applicant has agreed and offered to the condition of the variance that the landscape as depicted on the plans exhibit would be provided between the sidewalk and the Village Avenue. Any questions? And the last exhibit 15 is the photo of the silent property.
What is it building, John?
I'm not entirely sure. It looks like first floor is going to have some retail uses on it, lobby area, outdoor terrace. But as far as the actual, not sure what these two towers are. This looks like it's probably apartments. I'm not sure about that.
There's an entrance. That's what their entrance.
Yeah, so this is the general parking deck entrance for, general, residents and visitors to the site. And then this is their loading dock type entrance here. And again, ventilation for mechanical equipment is in this area here.
So we've got, so it has frontage on a one-way street and a frontage on a two-way street.
Yeah.
And the argument is that the free access is best from the two-way street. But the less pedestrian friendly access on the two-way street rather than the one-way street that's really oriented to cars. So it seems like a really unfortunate circumstance with our streets there, where we're kind of encouraging the service entrance from the road that may be more pedestrian friendly than from a car conduit that's the one-way street. But that's unfortunate, but I don't think there's anything I just wanted to clarify that. That just seems like an unintended consequence.
Yeah, Church Street, I guess, is one way this way, and then you have Mint here that they have frontage on, which is two-way, but it closes quite often for events and activities and stuff like that. And then you have two-way access here. So I think the idea is, for service delivery vehicles and for people who are wanting to visit the site, if their only way in and out was on Church Street, people would have to try to navigate this. Like, if you're going to circle around the block, you'd have to get back on 270. It's not a road; they just go quickly around the block, so it makes it difficult.
Get it?
What number of submission is that to staff?
Sorry?
What number of submission is that?
In terms of development plans, I'm not sure.
A couple times before.
I'm looking at Solomon, but I'm not sure what number we're on. To us specifically, this was the original application to us, but in terms of what they've been submitting through land development, I'm not sure what number.
Do I hear a motion to approve the variance?
Approve.
Thank you. With conditions.
Sorry. I make a motion to approve with conditions.
Thank you, Ms. Sun, for seconding. Conditions. All right, Ms. Shirley?
Approve.
Approve or oppose?
Approve. That's what I'm saying.
Approve. Right, approve.
Okay, approved. Thank you, Mr. Court.
Court, yes.
Mr. Shea?
Shay, yes.
Ms. Sun?
Sun, yes.
And Dryden, yes. So the is approved. All right, do I hear a motion to approve the finding of facts and conclusions of law?
Change to 17.
Okay,
Hypho, second part, will be provided.
Yes.
Past tense will be provided.
correct.
With that change, then we're going motion to approve
Okay, Mr. Shea, as amended.
as amended. Thank you.
All right, Ms. Sun?
Sun, yes.
Well, court seconds the motion.
I'm sorry, Court, Mr. Court, I didn't do that. Okay, I go with Mr. Court, so, yeah. Ms. Shirley?
Yes.
Mr. Court?
Yes.
Okay,
Yes.
and Dryden, yes. As amended, the finding of facts and conclusions of law are approved. Right. Very much. Okay, Ms. Shirley, you may step back when you will. When the board will. All right, we will now look at variance number 2025-00057 for property located at 2830 Huntingtown Farms.
there anyone here in opposition for 57?
Okay, no one in opposition. All right, Ms. Montague, you may continue.
Thank you, Chairman. This is case number variance 2025-00 to reduce setback. Property, the applicant is Four Corners of Charlotte LLC, represented by Romo Chugger of Four Corners of Charlotte LLC. For property located at 2830 Hunting Town Farms Road, owned by Four Corners of Charlotte LLC. 4-2, row A for setbacks for N1A zoning of UDO to reduce the collected setback 35 to 20 feet, 15-foot. Exhibit 1 shows the map of location off of Park Road, east of 45 and 57. Here shows the zoning map. It is N1A zoning districts. The house is right here. And this is Google Street Map. So the variance request is to reduce the front setback of 35 feet to 20 foot, 15-foot reduction. So here is the table. It's to A. It shows that the N1A zoning setback is 27, but per footnote 1 at the bottom shows that if it's the front setback on a plat recorded registered deeds, the front platted setback should exceed the zone requirement. Here is Exhibit 5 showing the recorded plat. The property is shaped. There is 35-foot minimum front setback, which is platted. There you can see that there is sewer easement. That's a 30-foot drainage easement. Here is the physical survey. And on the survey, it's the property. This is the location of the home. The green here is the 20-foot setback that they're proposing. And right here is where it's the existing setback of 35 feet. There is a 50-foot post-construction buffer in this area that didn't exist when the front setback was platted. Closer down, there's a 30-foot drainage easement here, and this one's a 15-foot sewer easement, and the rear setback controlled max building depth at the time that the front setback was platted. So a little later, when I explain the back setbacks, I'll explain a little bit more of.
So are they looking to expand the house? Is that what they're looking to do?
They are looking to remove the existing home and propose a new home.
Okay.
Yes, and so they're looking for more building coverage envelope. So without the variance, the building envelope is 2,673 square feet, which is in blue. It has dimensions of 16 feet at its shallowest point, 8 feet at its deepest point. With the variance, which is the green part here, and applying the proposed 20-foot setback, the building envelope gets increased to 4,004 square feet. Here, the standards for the variance, and your findings of facts, and let me know.
I have a question. If the plat recorded at the Register of Deeds supersedes the zoning district, are we going to vote on a variance to what's recorded in the plat or what's required by the zoning?
What's recorded in the plat is what we're requesting to minimize.
They would need to re-record. All approved points, they would record a plat so that the recorded supersedes what currently recorded.
Thank you, John.
And this is kind of at the front of the lot, right? Because the back of the lot is there's a lot of stuff.
And post-construction buffers.
Okay, go ahead.
Unnecessary hardships result from the application of the regulation because when the home was built in 1980, swim buffers were not an ordinance requirement. Per UDO Article 26.2A, swim buffer requirements were adopted November 15th of 1999. The hardship results from conditions that are peculiar to the property. The hardship results from small building envelopes created by the 50-foot construction and swim buffers. At the time the house was built, the rear setback controlled the allowable building depth. With the required swim buffers, the allowed building depth had been reduced. Without the variance, the building envelope resulting from the application of the 35-foot platted front setback, the 30-foot wide easement, 50-foot post construction and swim buffers, and the zoning required rear setback is approximately 2,673 square feet. The building envelope has dimensions of a depth of 16 feet at the shallowest point and 46 feet at its deepest point. With the variance and applying the proposed 20-foot front setback, the building envelope is increased to 4,004 square feet. The hardship does not result from actions taken by the applicant or property owner. The swim buffer was established by the legacy zoning ordinance after the house was built. The applicant and property owner did not create the lot, nor did they construct the existing home on the lot. The property owner acquired the property in 1998. Per the UDO standards of granting a variance in Article 37.8 A13 Roman numeral 3, the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, and that the public safety is secured and substantial justice is achieved. The front setback requirement of the UDO for N1A zoning is 27 feet, which is less restrictive than the plat reported front setback of 35 feet. The requested variance would protect mentally sensitive. The requested variance would allow the placement of a new single-family dwelling in a similar location as the previous home, consistent with the context of the property in the neighborhood dating back to 1980 when the existing home was originally constructed. Granting the variance would then alter the essential character of the neighborhood. And here is in Exhibit 10 shows where we posted the sign on the property.
And I see that the very first, the street view
The street view.
right there. So they're wanting to move the house, the new house closer to the road.
Correct. So there's 20 feet in the road.
And you're saying the current UDO is at 27 feet. That's what they're asking for, is the 27 feet.
No, they're requesting 20 feet from the
Okay.
35.
Gotcha.
We're not going by the zoning of 27 feet because footnote 1, we need to go by the platted
Yeah, the
front
platted
setback,
area.
not the zoning of 27 feet.
Gotcha.
We brought up the 27 feet to say that it's still less than what was platted of
Right.
35 feet, so it's a show.
Motion to approve.
All right, Ms. Sun has made a motion to approve. Do I hear a second?
Court second.
Thank you, Mr. Court. All right, Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Shea, yes.
Ms. Simmons, Dryden, yes. The variance is approved. Do I hear a motion for the finding of facts and of law?
Move to approve the finding of fact and conclusions of law.
Thank you, Mr. Court. Do I hear a second? Thank you, Ms. Sun. Okay, Mr. Williamson,
Williamson, yes.
Mr. Court?
Yes.
Mr. Shea,
Shea, yes.
Ms. Sun, and Dryden, yes. So we will approve the finding of facts and conclusions of law. So that variance is approved. Thank you very much. All right, we'll now look at variance number 2026-00001 for property located at 2125 Sharon Forest Drive.
We have opposition for this case.
Okay,
So I would propose that we just push that one over to the regular agenda and we continue to
okay.
2026-000. Well, we deferred that one.
Okay,
Continue over to 03. Is there anybody here in opposition for case? No.
okay. So we're moving to variance number 2026-00003 for property located at 162 Chevron Drive.
Ready?
Yes.
All right. This is for an application variance 2026-00003 by Tom Henry Design Company, represented by Thomas Podrasky. Hopefully I'm saying that somewhat close. Of Tom Henry Design Company, property located at 162 Chevron Drive, owned by Basil and Caitlin Polvika. Last names are variance from UDO Article 4.3, Table 4-2, Road D, to reduce the required rear setback from 40 feet to 20 feet. This would be a 20-foot reduction. Here's a vicinity map on Exhibit 1. This is down off of Robinson Church Road near 485, near that area there. This is the corner of Chevron and Pella Road, and the zoning is N1A. Aerial close-up of the property shows the existing house on the site. Exhibit number 3. Exhibit 4 is the variance request, again from Table 4-2, Road D, which is the N1A setbacks, the rear setback, which is 40 feet, and they're requesting a reduction to 20 feet. They have agreed and offered a condition that the variance is only applicable to the proposed addition to the existing single-family home as generally depicted on the plans provided by the applicant as part of the variance application, and the replacement if it was destroyed or damaged as set forth in Article 38.83G. So here's the Exhibit 5 shows the existing and proposed site plan. On the left, you have the existing site plan. The outlined in blue are the required setbacks. And this dark line here is a retaining wall. We'll see pictures in a minute. But essentially, the house is oriented towards Pella Road, but due to the shape of the lot, Chevron Drive is actually the narrower frontage, so the front setback is coming off of Chevron. And you have corner side setback along Pella Road, but that means that you have a rear yard applied here adjacent to Lot 8 off of Pella, and then a side yard setback off of this lot 8 off of Chevron. With proposed site plan, they're proposing is an addition to the house, basically make it symmetrical in design. And in order to accommodate that addition, they're asking for the reduction of this rear yard from 40 feet to 20 feet. And because of basically the topo in the rear prevents them from being able to do the addition on the back of the house. There's a storm drainage easement, which is shown on Exhibit 6 along the front of the property. So that would prevent them from going any closer to Pella Road. So again, setback is up here away from the house, but that storm drainage comes up pretty much to the front door. That prevents any sort of additions to the front of the home. And then Exhibit 7 is some pictures of the backyard. It's pretty extreme topographical difference along the backyard. They got a retaining wall not far from their back wall of their house, and then additional sloping up to the property abutting this house here. And you can see that topo there, sloping down and then dropping to the retaining wall. This is the proposed elevation and street view on Exhibit 8. Again, just trying to do an addition that would make it symmetrical in design and also give them some additional living space. And this is the concept that they've come up with. And then this is what it looks like currently from the street view. This is an image from a few years ago because I was trying to find one that didn't have tree cover, but it largely looks the same, except now there's a nice little picket fence along the front yard.
So it's to the left that they want to add.
Correct. Yeah, the addition would be here to the left. Again, is technically the rear yard on the side of the house. Exhibit 9 is just showing the proximity to the nearest adjacent home. So with the addition, roughly measured out from 20 feet from the property line here, and roughly 35 feet between the corner of their proposed addition and the corner of this house. So 35 feet of separation at the closest between the houses. Exhibit 10 is the variance criteria. All 4 need to be met. Findings before I dive into those.
Okay, John.
So Exhibit 11, considerations, unnecessary hardship results from the strict application of the regulation. Except for the subject property, every other house on the street has its front facade facing Chevron Drive. The front facade of the subject property faces Pella Road. That means that it's oriented functional rear of the home towards the lot side setback. In other words, when facing the front door of the home, right side, where the right side where the garage is located is actually oriented to the front setback, and the left side where the addition is proposed is oriented to the rear setback. Strict application of the ordinance requires that setbacks be determined by the shape of the lot and the street frontage, and on corner lots, the narrower frontage is the front setback, and the rear setback is applied to the property line that's opposite of the front. If the setbacks of the lot were dictated by the front facade of the house rather than the nearest frontage, then a variance would not be needed for the addition. Hardship results from the conditions that are peculiar to the property. The existing home faces Pella Road, which is a side street. There's an existing drainage easement that runs along Pella Road, which prevents any construction east towards the corner side setback. At the front setback in the existing garage prevent any construction north towards Chevron Drive. Placing the addition to the rear of the home within the side setback would encroach on the bay window of the kitchen, which you can see in go back real quick in this image here, the bay window, and then there's also a doorway there. So the placing the addition at the rear of the home and the side setback would encroach on the bay window of the kitchen, interfere with existing fenestration of the rear bedroom, and potentially require a new window be cut into the south wall to meet emergency egress codes. and those constraints compromise the ability to lay out a reasonable and functional floor plan. And the 6-foot tall retaining wall exists due to the severe grade change and limits the space in the established side setback located in the back of the house. An additional steep grade changes in the side setback behind the house creates substantial challenges in terms of excavation, waterproofing, and drainage considerations. Last exhibit 13 considerations. Hardship does not result from actions taken by the applicant. The conditions that contribute toward the hardship are pre-existing, and the owners have not made any changes to the usage or the structure of the house that would have exacerbated the conditions. Requested variance is consistent with the spirit and intent of the ordinance regulations. The proposed addition is in alignment with the spirit and intent of the regulations. It's only due to the unique circumstances of the lot and placement of the house that a variance is needed or requested. The house's existing footprint covers 8.2% of the lot, and the proposed lot coverage, including the addition, is 11%. And the total allowable coverage for the zoning district is 40%. The proposed 20-foot setback from the southern property line allows separation of about 37 feet from the closest neighboring house and does not deny the neighbor the fair use and enjoyment of their property. The applicant has offered and agreed to the condition that the variance is only applicable to the existing single-family home. The proposed addition, that's a typo that should be changed to match. So I'll go back to the slide here. Variance is only applicable to the proposed addition to the existing single-family home as generally depicted on the plans provided by the applicant as part of the variance application in replacement if damaged or destroyed as set forth in Article 38.3G. That concludes staff's presentation. Oops. Yeah. Last slide, 14 is the photo of the sign on the property.
Gotta refresh my memory on the, can you go back to the plan? Like plan, proposed plan. How does that get recorded? If the variance is approved, how do you attach the condition?
So the condition would be put on the decision letter. And then we obviously in our mapping software for our reviewers, this would be indicated that this parcel has received a variance. So those would be the two ways that anybody that here would be aware that there was a variance here. The condition of the variance then was attached to that decision letter.
So is that plan going to be in that mapping?
Yeah,
software?
the plan would get attached to the decision letter.
Okay.
John, can you see the plan from 3G Polaris?
Not from Polaris, from Charlotte Explorer. There's a layer on Charlotte Explorer that has variances and stuff on it.
I'd make a motion to approve with conditions.
Thank you, Mr. Shea. Do I hear a second? And so thank you, Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Say yes.
Sun, and Dryden, yes. So the variance is approved with the condition listed on the finding of facts and conclusions of law. All right, do I hear a motion to approve the finding of facts and conclusions of law?
Court move to approve.
Thank you, Mr. Court. Do I hear a second?
Second.
Thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Say yes.
Dryden, yes. Sun, so that finding of facts and conclusions of law are approved. Right. With permission, we'll take a 10-minute break before we continue with the regular agenda. We are ready to resume our meeting. Thank you very much. And we will now move to variance 2026-0001, which is on the recommended agenda. I mean, no,
Was
on the,
It was on the record.
was on the, but we moved it to the regular agenda. Okay. And this property is located at 2125 Sharon Forest Drive. And there is some opposition to this. So after the presentation, the opposition will have time to rebut.
Variance 2026-0001, variance to the Unified Development Ordinance, section 4.3D1 to increase the maximum required sidewall height from 20 feet to 27 feet, a 7-foot increase to the right side of the building. And from UDO Article 4.3D2 to allow the 45-degree building height plane to begin at the requested 27-foot sidewall height rather than the normal 20-foot sidewall height. The applicant is Reaching Freedom LLC, represented by Katel Patel of Leela Construction, and the property is located at 2125 Sharon Forest Drive, and it's owned by Reaching Freedom LLC. The property, exhibit 1 is showing the vicinity map, located in the area off of kind of between Queens Road and I don't know, 16, I guess. Property is zoned N1B, Neighborhood 1 zoning district. Exhibit 2 is showing the zoning map of the property. Exhibit 3 is the aerial close-up. Again, the property is vacant, and there's single-family house to the left and to the right. Variance exhibit number 4 is showing what the request is. Again, it's from Article 4.3D1 and 4.3D2, which are standards that are specific to duplexes in N1 zoning district. So if you're doing a duplex or a triplex in an N1 zoning district, you have to meet the sidewall and building height plane requirements from Article 4.3D. And the first one of those says that you have to have a sidewall height of maximum sidewall height of 20 feet, and that's measured from the finished floor to the eave, the lower edge of the eave of the house. And then there's a height plane, 45-degree height plane, basically that's measured starting from that eave or the 20-foot maximum sidewall height up. And so essentially any extensions above 20 feet have to be set back out of that 45-degree height plane. There are some exceptions for encroachments into that, such as your gable ends and dormers are allowed to extend into that 45-degree plane, and I can show that on a graphic here in a minute. So the applicants have agreed to condition that the lowest level of the structure be limited to unheated storage space as shown in the applicant's building plans, and a zoning hole be placed on the lot to prevent future conversion of the space to heated living area. This is a street view, exhibit 5, showing the topographic considerations of the property. It's kind of hard to see from street view, but there's quite a hill on Sharon Forest Drive dropping down from the street between the two streets that are on either end of this block. But you can see on the topographic map, this is a 686 topo line here. This is 666, 667 down here. Exhibit 6.
Real quick, the site map where you had the vicinity map.
I think that might be the wrong location.
I was
thinking about that just a second ago. I was like, I'm not sure that's right.
Okay.
So
This
sorry.
is off Independence.
Yes. Sorry about the mislocated property there. Topographic site plan, again, a little bit more detail on what the grade will be, what the construction of the building, the proposed duplex. They're at 684 feet at the upper end of the structure. And down at the lower end, it's 672, which is right roughly what the existing topo grade is here. The 670 topo line is right there. So they're at 672 here. And then at the upper end, 684, 680 are here. And this line here is the 684 line. So a fairly substantial amount of grade change within the property. And that property is, let's see if we got dimensions on there. They're on there. I can't read them on that version of the plan, but it's not a, this is 10 feet of distance here. So we're probably 60 foot, 60, 70 foot wide lot. 70 foot wide lot. So rendering showing the kind of conceptual elevation of the property from a 3D perspective. So they're compliant with the sidewall height on the upper end, 2-story elevation from the finished floor to the eave. But due to the grade change to meet the sidewall height, they would need a variance to allow 27 feet from the finished floor to that lower eave. So Exhibit 8, elevations. Again, left side is compliant with the sidewall height and height plane. Gabled ends, again, allowed to encroach into that 45-degree height plane. The required sidewall height, if it was 20 feet from the finished floor, you'd be stuck down here, and then your height plane would be here. So this living space would not be allowed to encroach into that 45-degree height plane. So what they're asking for, again, is the increase to the sidewall height to allow sidewall to be 27 feet to the eave, and then the height plane start from that measurement instead, which will allow the gable end to encroach into that height plane. Exhibit number 9 is from the applicant's plans, just showing that the lower level is limited to unheated storage space. There's a little mechanical room, a heated vestibule to the staircase that goes up to the upper level. Exhibit 10 is the variance criteria to be met in order to warrant granting the variance request. And I'll give you a minute to look over the findings before I dive into those.
Okay, John.
Unnecessary hardship does result from the strict application of the regulations. Strictly applying the 20-foot height limit and height plane would create unnecessary hardship because of the steep slope of the property. The grade drops make it impossible to maintain a consistent wall height across the lot without exceeding the 20 feet at the lower end. And the variance is necessary to create a safe, functional, and visually consistent structure given the unique topography. Sidewall height and the height plane requirement in combination with the lot's topography create hardships for constructing a duplex that would otherwise be permitted on the lot. Hardship does result from conditions that are peculiar to the property. Hardship is caused by the property's steep topography, which is unique to this lot and not common to the surrounding area. The elevation change requires additional wall height to achieve stability and usability. Within the building envelope, the topography drops 12 feet. In Exhibit 12 considerations, hardship does not result from the actions taken by the applicant. The slope of the land is a natural condition that existed prior to development, and the applicant's proposed design simply accommodates the natural terrain rather than altering it excessively. The requested variance is consistent with the spirit, purpose, and intent of the regulations. Granting the variance aligns with the spirit and intent of the ordinance, which is to control the height for safety and aesthetic purposes. The wall, although it's measured at 27 feet on the lower side, does not compromise public safety and neighborhood character or the visual intent of the 20-foot limit because the increased height is caused by the natural grade difference rather than mass or volume of the structure. And the applicant has offered and agreed to the condition that the lowest level of the structure be limited to unheated storage space as shown on the applicant's building plans, and a zoning hold would be placed on the lot to prevent future conversion of the space to living area. And with the condition, the sidewall height of actual living space on the right side of the duplex would be limited to about 17 feet. So basically the upper 2 stories would be the living space with that condition. Exhibit 13 is the photo of the sign on the property. And that concludes staff's presentation, and I believe it would be now the turn of the applicant to present.
Any questions for staff?
The it's a duplex, and
Proposed duplex, yes.
both units have unheated storage space underneath the bottom of it.
So the unheated storage space is all in that lower end that has
Okay.
the higher elevation due to the topo change. And then the plans showed 2 areas of storage. So
Oh, I see. Okay.
this part would be
Right.
basically crawl space because
Right.
of the topo. And then once you drop down to that lower area, that's where they're able to have that higher height due to the natural grade for the creation of the storage space. And I presume that the way they set that up, it'd be storage for unit A and B.
What,
There's common space down there. Sounds like
Generally.
interesting. Yeah.
and we're going to set in place something that says that this area can never be turned into living space
That's correct.
with the zoning hold,
That would be the intent
unless they come back years from now and ask to have
for
it
another
rezoned.
variance or something like that.
Interesting. Okay. All right, I understand the topography. I don't know who will speak after, but what does it look like from the house that's next to it or behind it with this extended height? Do you have a picture of that, sort of?
I mean, that's probably going to be your best kind of view or indication of
Right.
what that was. If you imagine the house that's next door, is here. There's my laser over here. So these 2 houses here, they front on this other road over here. So
So that height
27
would
foot
be
of height is going to be here,
back at their backyard.
in their backyard, and there is some trees and stuff here that would provide some amount of screening.
And what does the topography do from there? Does it keep going down the hill or up the hill?
It goes slightly back up. Where's there? So it does go slightly back up towards the other street. There's like a drainage.
Gotcha.
It's not got a stream or anything in it, but it's just a low point. But we're back up to 668, kind of at the next street. So
Okay.
It goes up a few feet, but not to the degree of what it is up here.
Is this a subdivided lot?
It's a legal lot of record. I don't know when it was created.
Okay.
A lot of times when we put conditions on a variance, it's connected to mitigate the issue. It seems like not allowing people to live down at the very bottom doesn't really mitigate the issue of being tall.
Right.
Is there a connection? What's the connection between the condition and the mitigating factors? What?
So when we adopted the UDO, the intent was when we had that sidewall that when they're going in infill lots, that we weren't, I guess I want to say we weren't overpowering those existing homes. But the way we wrote sidewalls, we gave no exemptions for if you're on a sloping lot. So what they're really asking for is unlike average grade for height, we have average sidewall. We don't have an average. So that's why they're there. And so kind of why we asked for the condition on unneeded spaces. So that way, the adjacent property wasn't getting a 3-story home, right? Except so the reality would be you're really getting 2 stories of living space, and then you'd have that unheated storage space, like a crawl space, something like that. It'll be a little larger than a crawl space, but that's why we came up with the condition.
Thanks.
Any other questions for staff? Okay, who is here to speak in opposition? The applicant's presentation. Okay, applicant's presentation, if you will step to the applicant's table and I can swear you in, please. Okay, all right, do you solemnly swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth? Okay, if you will state your name and spell it, please, for the court reporter.
Yeah, Ketal Patel,
Spell it, please.
Ketal, and last name Patel, Patel.
All right, sir, you may present this to make that turn.
Do I have to speak?
If you want to present.
Okay. That's it.
If you just want to, if you want to bring your time.
Because-
for the opposition, that's fine too.
Oh, okay. So basically, we are asking like 7-foot variance. I mean, 7-foot building height. Right now, currently at the 20-foot on the front side of the building and the back
Who are
side.
you talking to?
You need to talk to
sorry.
me.
We need to
Or
talk
us.
here.
Oh, I'm sorry. I
I don't understand
thought,
what you're saying.
That's okay.
I'm sorry. I apologize for that.
That's fine.
Yeah, so currently in the front of the building is a 20-foot, the building height up to the eave from the finished floor, and the back of the building is significant drop. It's about 12-foot drop within a 70-foot, from the building footprints. So basically, if you want to maintain the building height, we have to go up and to maintain the height. So if you measure the building from the lowest point of the building, which is on the right-hand side of the corner of the building, to the eave is 27 foot, and the front side of the building is 20 foot. So Mr. John explained about the 45-degree plane measure from the side setback. So hardship is caused by the unique topography. We haven't created any condition or anything, as the lot is by itself like that. So there will be no impact on the public safety, and it is consistent with the ordinance intent. You can see the existing, the proposed 27-foot condition. This is by the height plane, which is 45-degree on the right-hand side.
So, Mr. Patel, you're asking for this variance so that you can keep the roof line straight across? What
Yeah.
stops you from dropping that other building? You would still share a wall. And so your roof, you would have two sets of roofs. Is that not feasible?
No, it is not feasible. And it will not look, that consistent throughout the building. This will give, the more like, the better look and consistent look.
Okay, go ahead, continue.
So when you see the building from the outside of the road, it doesn't look like, that you're going above, the height limit. it looks consistent when you are driving the road or from the back of the building because of the condition of the property.
Mhm.
That's the end of the presentation.
Okay.
Thank you.
Any questions from Mr. Patel? All right, thank you, sir. I appreciate it.
Thank you.
All right. Who is here in opposition to this? You would like to step to the applicant's table? All right. Do you solemnly swear or affirm that the evidence you shall give in this to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, if you will state your name and spell it for the court reporter, please.
Jennifer Lohman, Jennifer, Lohman, Loman.
Okay, Ms. Lohman?
I'm actually not sure if I oppose it or not. I just have a lot of questions.
Okay.
There's a lot of traffic at that spot. It's at a four-way. Actually, it's a two-way intersection, but it's right on the corner. Right now, they're renting rooms, so there's a lot of cars. There's a lot of deliveries and Ubers. So I guess my question is
Renting rooms.
the house, the landlord.
Thought it was empty.
The lot in question is vacant. It's not a house.
There's no house there.
What property are you referring
If you look up there.
Look
ma'am,
behind you and tell us where you're talking.
You're adding a building to the back of the property?
Yes.
Are you going to, I'm really concerned about how many people are going to be living on that parcel. There's already a lot of traffic. The people kind of come and go, they get evicted, there's fights, there's a lot of people, a lot of traffic. So I'm concerned about another building with even more people living there. I live 3 houses down.
Where in relation to that? Can you-
If that's on the corner, I'm 1, 2, 3, 4 houses down. But I walk all the time and there's no sidewalk there. They park on that hill a lot. So trying to walk down that hill, you have to walk around the cars. It's a really bad hill. So people driving down, it's very precarious walking in that one particular spot. I thought from the pictures that maybe he was adding a 3rd story to the building.
No,
Yeah, are you talking about the building on the corner?
Yes.
Gotcha.
So if he's building a new building in the back, that makes sense. But again, I'm just really concerned about crime, about traffic, cars. There's already, I don't know how many people live there now at the rental place, but there's a lot of in and out, different people. I don't know if they rent monthly. So it's just very concerning to me with the people and the traffic.
so this building that this is going to be a duplex.
Hmm.
2 levels, looks like, because he's asking for the variance so that because of the topography,
Hmm.
the bottom level would be unheated storage space.
Yep.
Yes. Oh, sorry. I apologize. Okay, so any other concerns or statements that you would like to make?
No, I think I've,
Okay, well, thank you very much. I
Thank you. Appreciate it.
coming.
thank you.
All right. Yes, sir.
You had asked the question earlier about when the lot was created.
Yes.
I've looked on theirs. Looks like the lot was created and the plat recorded in April of 2025. But it's properly and legally created.
Okay.
The legal lot.
Okay. All right, board, some discussion.
Yes, I have a question about the corner property. I'm probably should concentrate on the property we're talking about, but when that was platted, did that create, I mean, what is the rear setback on the property?
So it's the plat is showing the recorded plat shows that the existing house on Briardale has a 35-foot rear setback.
Okay.
And then this lot would have a 35 rear setback and a 30-foot front setback.
I guess it fronts to where the driveway is, and maybe that's a garage that's detached, that's,
So it fronts on Briardale. The corner lot fronts on Briardale, because that's the more narrow frontage. So the Sharon Forest side is a corner side setback.
so the rear of the property is, that shares a property line with the property we're talking about.
Right.
That there's a 35-foot setback from that property line to the home. And then there's a garage in between there. I guess,
Yes, that garage is in the rear setback, yeah.
where it's legally allowed.
Right.
Right.
Any other questions or comments? And city is recommending this property.
Yes.
That is correct.
Yes, definitely.
I make a
Okay.
motion to approve.
So if we could, I would encourage the board to have some discussion on each criteria.
Yes,
since
let's
this
look
was
at
not
the-
on the recommendation agenda.
Since we're, all right, so the first one is unnecessary hardships would result from the strict application of this regulation. I don't know that,
He has the right to develop the land,
correct.
so.
And conditions peculiar to the property, yes, because of the topography. The hardship didn't result from the applicant. It looks like he platted the land in 2025. And we are agreed that it's consistent with the spirit, purpose, and intent of the regulations.
Sure.
All right, I want to make sure that we highlight number 14, the applicant has offered and agreed to the condition that the lowest level of the structure be limited to unheated storage space. And that a zoning hold will be placed to prevent future conversion of this space to heated living area.
I'm gonna make a motion to approve with condition.
Right,
Sounds like good.
Mr. Shea. Approved with conditions. Ms. Sun seconded. Mr. Williamson,
Williamson, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Son, yes.
and Dryden, yes. And the finding of facts and conclusions of law. I don't see any, does, with the condition, you know, that's in there. Okay, do I hear a motion to approve the finding of facts and conclusions of law?
So moved.
Thank you, Mr. Court. Do I hear a second?
1 second.
Ms. Sun. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Mr. Court,
Court, yes.
Ms. Sun,
Son, yes.
and Dryden, yes. So the variance is approved. All right, we now move to variance number 2026-00. Yeah, here, 0004. For property located at 2107 Roslyn Avenue.
Right.
Okay, Mr. Kinley, you may begin.
All right. So this is variance 2026-00004 by Roman. Apologize, I'm not gonna. Ridgecroft, of Roman Design LLC for property located at 2107 Roslyn Avenue, and it's owned by Scott and Lorian Manus. And the variance is from Article 4.3, Table 4-2, Road D, to decrease the rear setback from 25 feet to 11 feet, which would be a 14-foot reduction. And a variance from UDO Article 18.2 B3 to allow unheated space to encroach more than 25% the depth of the required rear setback and more than 50% the width of the dwelling at the rear building line. So the vicinity map of the property. I think we're in the right spot this time. Off of Rawlins Ferry and West Trade Street. Exhibit number 2, zoning map. Property is zoned N1D zoning. And exhibit 3 is a close-up aerial view kind of from the front of the house looking towards the backyard. And you can kind of see off the edge here, existing deck in this image.
So the property
Sorry.
to the right, that's not theirs, right?
No, this
Okay.
is the neighboring property
So
here.
there's a, okay,
It's just the angle of the property is
all
kind of
right.
image.
Oh, I see the corner.
This is the house here. Again, aerial close up, kind of looking at the backyard of the house. And this is the existing deck. What they propose to do is put a roof over the deck here. And that's the reason for requesting the variance request. There's a street view from exhibit 5 showing the kind of the into the backyard area. In the corner of the deck, you can kind of, it's hard to see, but there's the staircase coming down from the deck is right here, the back of the house. So Article 4.3, Table 4-2 for N1D says that the minimum rear setback is 25 feet. And Section 8.2B3 says that you can have unheated space that can encroach into your rear yard, but the depth of that is limited to 25% the depth of the rear setback, and the width is limited to 50% of the rear building line. So when we look at the applicant's survey and survey that shows the existing improvements on the lot, the existing deck here in the green outline, and you can also see the existing corner of the home, that encroaches, the existing home encroaches 5 feet into the rear setback. That's a legal nonconformity that was created when the UDO went into effect, because pre-UDO, this was zoned R8, which had a 20-foot rear setback. And then when the UDO went into effect, that changed to 25 feet and created this nonconformity with the existing house itself. The deck, on the other hand, was built, I think let's see what's in here. I apologize. Not sure we know exactly when the deck was built, but we were unable to find any permits or anything for the deck. And if you notice, it exceeds the 50% width. So this would be the rear building line here, basically the rear of the house at the widest point. And then this is almost 86% the width of the rear building line. So we couldn't find any permits for the deck. And so it's an apparent violation However, there's not been any recorded code enforcement action, and there's not been any complaints from any of the adjacent property owners reporting a potential violation to the existing deck here. So it's really kind of unclear how we got this sort of a deck situation. The current owners did not create that situation. That was a prior property owner that did the deck. So again, we just don't have the documentation to really know for sure. But what's being requested now is that from the current property owners is they would like to be able to put a cover over that to create some covered outdoor living space. And staff's concern about that is that that would kind of increase the degree of nonconformity of that a violation that was created by the prior property owner.
I don't understand your blue area though. Did you say that correctly?
So the area, I haven't talked about that yet, but the area in blue is potentially areas, that would be able to have some sort of covered outdoor living space. Yeah, it wouldn't be directly attached to the house, but they could put a pergola up or, some sort of sunshade, that kind of thing in the backyard and still have some covered outdoor living space. It just wouldn't be over the existing deck.
And I don't mean to steal your thunder, but have you advised the owners that their first step might have been or should have been to get the deck approved or varianced?
So that's part of what the reason for the request is. In the variance request, it would bring the existing deck into compliance if the variance is approved.
You do both at the same time?
Right. So the variance to reduce the rear setback would resolve the legal nonconformity of the existing house and the deck encroachment. And then the variance to the section 18.2B3, basically that variance would allow that to exceed more than 50% of the width of the building wall. So that addresses the compliance issue with the existing deck. And then by way of granting those two variances, you would also be allowing them to be able to cover that existing deck with the roof.
Well, Mike, is the deck safe? I mean, has it been inspected? That's, they're asking for us to grandfather that deck. But what if it's not safe? Then do they have the right to tear it down and build it because we've approved the variance?
So staff has not completed any sort of building inspection of the deck. I think the applicants have, their agent will be able to speak more to that. As far as, if the variance is approved, they would be able to tear the deck out, put a new deck in, as long as they're within the revised setback that's established by the approved variance, and they meet the requirements of the section 18.2. They would be able to take that down, replace it, whatever they need to do if there was repairs that need to be made or a replacement that was needed.
But right now they're out of compliance even with their house because of the home encroachment, the 5 feet.
Right. That's allowed to remain
non-conforming
because
right
it's a legally non-conforming.
Okay.
So they don't, if it wasn't for the fact that they were asking for the variance to allow for the roof to go over the deck, it would be able to stay as it is. Now there's still this issue of a deck encroachment that's potentially a violation, but it's been there for 15 years. No one has complained to code enforcement about it. So we've not done any active enforcement activity on that, but it could potentially come up as an issue now that staff has been made aware of it. So that could be an issue for them if the variance isn't granted. Code enforcement could take action against them at that point.
Then it would definitely be impacted if they tried to sell the property, correct?
Yes.
Yes.
Yes. If the house was to go up for sale and this was noted as a potential violation, that could cause issues for them at closing.
All right.
Exhibit 8 is the variance criteria. I'll give you all a minute to look over the findings before I jump into my presentation.
Okay, John.
So unnecessary hardship does not result from the strict application of the regulations. The hardship is because, or doesn't result from the strict application of the regulations because the structure is legally non-conforming. When the home was built in 2008, it met the 20-foot rear setback under R8 of the legacy zoning. And when the UDO went into effect, the zoning translated from R8 to N1D, and the rear setback changed from 20 to 25 feet, which created a legal nonconformity. And a reduction of the rear setback would reduce the setback to be 9 feet less than the setback under the legacy zoning ordinance. So the reduction, in other words, the reduction of the rear setback would take it back to be less than what it even was under the legacy ordinance if we were to grant that requested variance to the setback. The existing deck exceeds the allowed encroachment into the rear setback for unheated spaces. And per the applicant's survey, the deck is 11 feet from the rear property line, which encroaches 44% into the depth of the rear setback. And the deck is 26 feet wide, which is 86% of the width of the rear building wall. The 25% depth and the 50% width standard of Article 18.2B3 was also in the legacy ordinance. Staff was unable to find a building permit for the deck on record, so it's unclear if the deck was properly permitted or not. And the applicant stated in their application that they believed it was a violation. Code enforcement doesn't have any records of any notices of violations for the deck. The requested variance to allow the deck to be covered would increase the degree of nonconformity of the unheated space encroachment, and per Article 38.3 of the UDO, alterations to nonconforming structures cannot increase the degree of nonconformity. The fact that the lot has a 25-foot rear setback and an existing deck that exceeds the allowed encroachment for unheated spaces would not be a hardship that results from the strict application of the ordinance. And hardship does not result from the conditions that are peculiar to the property. The lot is a legal lot of record with an area of 7,171 square feet, which is more than twice the size of the minimum size required for N1D zoning. And there's space on the lot for covered outdoor living spaces that would not create further expansion of the nonconformities. And the hardship does result from the actions that were taken by the applicant. Hardship results from the actions taken by the applicant or the property owner. The previous owners built the home and the deck. However, the actions of the current applicant and property owner would increase the degree of the nonconformity. Requested variance is not consistent with the spirit and purpose and intent of the regulations. And the purpose of the rear setback regulation is to provide consistent separation between buildings within zoning districts. The requested reduction to the rear setback by more than half of the existing home is already 20 feet from the rear property line at the nearest point, and the smallest rear setback in N1 zoning is 20 feet. The purpose of the allowed and limited encroachment for unheated spaces to provide property owners with opportunities for structural unheated living spaces within setbacks. The 25% depth and width regulation is not new to the UDO. The legacy zoning ordinance also included the same standard, and the existing deck already exceeds that allowed encroachment, and the applicant's proposal would further increase that encroachment. And the UDO would allow for other options for a covered outdoor living space, such as detached accessory structures. And last slide, Exhibit 12, is just a photo of the sign at the property. That concludes staff's presentation, and next to be the applicant.
All right. Any other questions for John, board?
All right.
So John, just to be clear, all they're asking for is a roof over this. So that would be the top and like posts, no screening, no.
As far as, right, they're not proposing to enclose it. I mean, there's nothing that says they couldn't screen it in. But yes, they're proposing a roof over it.
Okay. So we have the applicant. Okay.
To change this, to just roll.
Yes.
If you place everybody that's going to speak needs to, yes. All right, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? All right, if each of you will state your name and spell it for the court reporter, please.
Roman. Last name is Ryzhkov.
Scott McManus, and it's spelled here, SCOTTMCMANUS.
And Lorianne McManus, LORIANNMCMANUS.
All right, you may begin.
Okay, so we are proposing just to get a roof over existing deck. And you had a question earlier if deck is safe. So we had an inspection by a general contractor, and also one of my engineers came over to the job site and we inspected, the deck. So foundation is properly done. It has 6 inches depth under every single post, and posts are 6 by 6, which is pretty sturdy to carry the roof weight. And the deck shape itself, is in a good condition. Over 15 years, it's been properly maintained, and we've noticed no violations in construction. So pretty much it's safe and sturdy.
Okay,
And
thank
I
you.
think it will withhold the roof weight itself with no problems.
Okay,
So another point of having the roof over this deck is to protect owners from, having their good time outdoors, because right now they have trees on their neighbor's property, which has given their, gummy stuff on all their furniture, on deck floor, and every piece of equipment they have there. And also there is a post light which has been installed by the other neighbor, which bothers them. It's like super bright. And but main point to have this roof over just to enjoy outdoor space due to limited space on their backyard, because they have like a tiny tiny spot. And also this deck is 17 by 10. It's pretty tiny, and they use this deck to to carry all the stuff through the back door, because this is the only way to their second floor which they can access it. And but more issues, I would like to give a word to Scott so he can tell you about his experience. Okay.
Thanks to the board for hearing this variance request, and thanks to our neighbors, Ms. Wenda and Ms. Brenda, for showing up in support. So just a quick summary. We would like to show this deck was in place when we purchased the house. We were not aware of any issue with permitting. We were told that everything was on the up and up. So this is kind of a new finding for us. As far as we know, this deck has been in place for 15 years. We could be reasonably certain of that because, as Roman said, our stairway going up is very narrow. You can't carry a stair up there. So the only way to get furniture upstairs is actually via this deck. So reasonably certain it was there when the building was constructed, permitted or not. And I just want to reiterate, we're trying to put a deck over this. We're not trying to expand the footprint. We will not further encroach. This is just trying to make more usable space. And the reason for that, it's a little hard to see here. Our property is surrounded by very poorly maintained trees that drop rotten fruit onto our property. In addition to, they are heavily infested with aphids we've hired a tree removal company and a pest removal company that tell us these aphids drop what they call honeydew, but it's this black substance that's sticky. It drops on the entire property. So just to address the staff saying that we have all this, that blue property that we could build on, we actually can't because there's so many trees overlying that property is hard for us to use. So this is an example of our patio and the deck where we had pressure washed it just this last spring. And you see 2 weeks later, there's already another residue that we had to try to clear again. We try to use that outdoor space. We really can't. Our dog likes to be up there. So it's really impacting our ability to use probably half of our yard, to be honest. We've spent over $10,000 paying. We don't own any trees, first of all. We spent over $10,000 pruning and removing our neighbors' trees, which they were very grateful for, but trees grow back and it's becoming prohibitively expensive. One of the trees we were quoted $20,000 to remove, which is kind of undue for us to manage. We tried different umbrellas, different coverings, and we found that sap actually seeps through. So if we did not have that deck there at all, that sap would still come down and we wouldn't be able to use that deck space. So regardless of whether or not it's there, it kind of inhibits our ability to use that space. And again, just pointing out the speed that comes back. Like we've tried to clean it. We actually replaced, as Roman said, we have tried to maintain this. We replaced all of the surface boards with composite because we were told it'd be easier to clean. We thought maybe that was a reasonable approach. Spent over $15,000 doing that. It's not. It's easier to clean. Still not easy. With reference to the light, there's a utility pole in our neighbor's adjacent property. That light basically did not work before. The utility replaced with an LED that shines down on our property. We've asked them to adjust the angle. They said no. So it shines down on our property, and we don't have pictures of it because for our neighbors, we don't want to call anyone out. But we also have neighbors that installed rooftop solar panels down the line that reflects back up at us. And our neighbor has floodlights for safety that shine on that space. We're just trying to get a little cover from all of the light that comes so that we could use that space that we have. This is just more evidence. So the neighbor behind us has a dilapidated property. There's a structure there that often has stray animals that nest. So think stray cats, raccoons, everything you think of. Yeah, so I actually frequently go over there and kind of cut back the vegetation. I try to clear the animals out of there, but it's another hardship that we have in using that ground space that we have because there's constantly things coming over, and frankly, just the vegetation coming through makes it hard for us to use. Again, just want to reiterate that deck's been there for more than 15 years. Nobody's ever expressed a negative opinion of it. We obtained signatures from the 3 adjacent properties. So that doesn't help. If you saw the adjacent properties when staff was showing the satellite, we have signatures. They've all approved. We've also received signatures or verbal approval from everyone that we spoke to in the neighborhood. Again, we have 2 lovely neighbors who showed up to support us. So we're not aware of anyone that's in opposition to this. Just an example of the signatures, which we can provide if you would like to see the written copy. And just a summary that I don't need to beat up. We're trying to make a really modest request. We're trying to demonstrate that we've worked with our neighbors. We've done everything we can to try to use this space. We're kind of out of options. We understand that the deck was likely not originally permitted, but we're trying to rectify that, as staff said. Kind of, a 2-for-1 on this variance. And we understand the ask there, but we believe this is modest. And we've demonstrated we have neighborhood support. And to my knowledge, nobody has been in opposition of this.
What is the room above the garage? The bedroom, master bedroom? What is it?
It's kind of a bonus room that I think was a later addition. I'm not certain of that. I actually, just from this process, we went and looked back at different permits. I think it was an addition, but I actually could not be certain of that.
I'm confused about, John, maybe this question's for you. I'm confused about how to me, that looks like an addition. Because that room was specifically built, well, maybe not, maybe I'm wrong, but it's got sliders or patio doors. If you show the other picture, it's got patio doors, so it was always designed to have a deck. Now it's possible, I guess, that they were just windows and they were replaced with patio doors, but to me, that looks like, at face value, it looks like it was an addition that was put on there, and the deck was part of the gig, and that whole thing was illegal. But you can't tell from the permit whether, if the house footprint is in fact what you see there, or if it was something else. You don't know.
The house. Get a different mic. This one's buggy. As far as I could tell when I was searching through the building permits, the house itself met the setbacks. And that includes where the garage is. There was a building permit that showed the proposed garage, and it had the 20-foot minimum rear setback indicated on that plot plan.
Okay.
So the garage and the space above the garage compliant, permitted, A-OK. Now that plot plan did not show a deck. Maybe, like you said, maybe it was part of what was planned there, but it wasn't shown on the plot plan.
And just to clarify, when I said addition, my understanding is that made it a heated space. So I do believe it was always there. And again, from our perspective, purchasing the house, it appeared that it had always been there. We did not understand that it, there was no permit granted.
So the conversion to a heated space and the appearance of the deck may in fact go hand in hand.
That's possible, but again, we don't have any documentation to know
Just
for
trying to figure
certain.
out how it happened.
And there's no plans to like increase the size of the staircase or anything like that? You're just asking to put a roof?
Absolutely not.
Just a roof.
But as is right now, you're gonna have a title issue if you sell it with a deck, because the deck is non-conforming.
Right.
That's what we learned.
Any other questions for the applicants?
Have you guys looked at electric awnings, things like that?
We have, we were told that because they roll, that would gum up the system, that the honeydew that drops down, it basically makes anything non-permanent at least won't last long.
Any other questions? Any other comments from you guys?
No.
All right, thank you very much.
Thank you.
All right, the board will now go into some deliberations unless you have any other questions for staff before we do that. All right, so we are being asked to do two things. Fix the non-conforming or legally conforming house that was, and then to allow a roof over this deck and then thus making it conforming by reducing the setbacks. Do I have comments or thoughts?
I think there's a hardship in that they want to have use of that portion of the property, and they're not able to do that the way they've demonstrated that they're not able to make use of that portion of the property. I really don't think that there is anything peculiar to the property. I mean, I get that it has sort of a diagonal backyard, but it is a large piece of property. And so I don't feel like it really meets the criteria for peculiar conditions peculiar to the property. So I don't know that I would grant this variance.
Well, they have done their due diligence with the neighbors, it seems to, with their signed agreements to this. And it's, the hardship doesn't result from conditions, well, in a way they do, because peculiar to the property in that the deck was built out of compliance to start with, over which they had no control.
Yeah, and I think I think if the variance was to allow for the deck, I think that'd be fine. I mean,
That was I was gonna
Yeah.
make that proposal, but
right.
I'm with John. I'm with staff. I think it's two negatives can't make a positive here. But maybe the first step is we approve the deck so that the house is legal non-conforming and the deck is legal non-conforming. But we can't condone the building of the roof over it. That doesn't meet the applicant's desires, but at least gets their house legal along with the deck. I think it's an option that we should discuss.
Well, we might need to ask staff if that bends the request too far.
Well, we need to come out of,
Yeah,
we would need to come out of.
out of closed session if we're gonna do that. Mr. Williamson, what are you thinking?
If we're finding it acceptable to approve the deck, why can't we find it acceptable to approve the roof? I'm not sure I follow that.
Well, my concern is, and this is zoning deals with this every day. you've got people who illegally did things, and now we're giving the approval to not only approve the illegal stuff, we're approving stuff that's already out of conformity, like the deck that's 86% wide and all this stuff.
Yeah.
I think it's unfair to people who follow the rules. These guys are trying to follow the rules, and it's unfair to people who follow the rules and get penalized. These guys before them, the owners before them, in my opinion, clearly did something illegal. They heated that space upstairs. They converted it to a space. They put a deck on there, all under the radar, and they're not going to get penalized for it. The people who are getting penalized are the people who own it now. So I'm just trying to get them to a point where they're whole, but I think staff is completely correct. You can't completely condone what's happened before them, which was illegal, in my opinion.
But
Well,
by approving the deck, are you in fact condoning it?
Well, that was me. So,
Okay.
and it's I think that we may need to ask staff later when we get it, but it's my understanding that a deck has lower restrictions than a covered deck. So a covered attached roof deck is not the same as just a deck off the back here.
Okay.
Ms. Sun, what are your thoughts?
I agree that we can make the existing structure legal. Not sure about the roof.
Well, see, I'm inclined, following Mr. Williamson's thoughts, if we're going to say that even though it was non-conforming and somebody built it, they shouldn't have built it, we're going to approve the deck, then why can't we just go ahead and approve the roof over the deck? I mean, if either we approve the deck with the roof or we don't approve it at all, it seems to me. I mean, going halfway is not going to affect future variances. I mean, this is a very unique situation, and unnecessary hardship would result from the strict application of the regulations. I think it would be an unnecessary hardship if we are proven, and if they had come to us and said, we just want to get this deck approved, then we would have probably said, okay. But they're asking to put a roof over it. They're not asking for walls. They're not asking for screened. They're just asking for a roof. So, I mean, if you approve the deck, then we should approve the roof.
Yeah, I think that there's reasons why there are more restrictions on a covered deck than there are on a regular deck, and one of those might be, you're probably on a covered deck a whole lot more, so you're creating more of a nuisance by being in the setback, looking over your neighbors, or in that area. There's the reason for the setback is to kind of buffer you from adjacent properties, and whether current property owners have an issue with that, or future property owners, or whatever.
Well, evidently they don't. I mean, they've got all most of the people.
Sure, but I mean, but it also sets a precedence for around the county. I mean, around the city. Like, is everybody going to be able to build a house right up into their setback and build what? I mean, a covered deck is essentially an extension of a house. It's basically like you're building the house out into the setback. So, is there something peculiar on this property that makes it so that we need to grant this variance? Is there? I mean, they got a lot of room on this property. It's a big piece of property. It's big and wide. Is it so tight that they can't make other use of this property?
You keep saying it's big, but it's only 7,000 square.
Yes, not really big.
It's big for the district.
For the district, right? So for their zoning area.
But I also agree. I mean, they've brought some convincing evidence of their ability to use the rest of the yard, but because of the trees and the infestation of aphids and stuff like that. Now, I don't know that that's conditions peculiar to the property, but it is kind of peculiar to the property. They got all these trees that, I mean, it's hard to use a deck that is constantly under attack from tree stuff.
If I could suggest to the board too, for anyone who feels that one should be approved but not the other, if you could, identify some facts
you have
supporting
to-
different
right.
criteria.
Thank you. I don't. Because for me, I think it would be an unnecessary hardship if we didn't approve this. Because it says in absence of the variance, no reasonable use can be made of the project. Well, some reasonable, maybe some use, but not safe use. And the deck's already there. And I think that the trees and the all that stuff is peculiar to this property in that it's a small area. It's definitely not anything that the applicants did, that's for sure, because they bought it this way. And I feel like that allowing them to add the roof does fit the spirit and the purpose of the regulation. Keeps them safe and secure. I mean, I know what it's like to have a big fluorescent light that beams into your house every day. Those are just my thoughts. And I feel like if we're going to go far enough to approve the deck, which we can go out of session and ask if that's a feasible thing from the city, then we should approve the roof. Okay.
I would agree with Deborah.
Okay, so motion to approve.
Okay, so, well.
Want to come out?
We'll
Talk
come-
to staff?
Yeah, let's come out of closed session so we can ask staff. What are your feelings about the half approval?
So as I understand it, and look to Tari and Paige to correct me if I'm wrong, but as I understand it, you all have the ability to approve a variance in part or in whole. And you also have the ability to place conditions that the applicants accept on a variance approval. So you do have some flexibility there to make some changes to
So
what
what
the
kind of
request
conditions
is.
could we put on it to guarantee that it stays just a roof?
Well, one example of condition could be that it would never be enclosed or screened in, which, part of the reason, if you look in Article 38, talking about improvements to non-conforming structures, it says basically any alteration or modification to a non-conforming structure is not allowed, basically, because it would increase, or at least any modification that would increase the degree of nonconformity. So there's not separate requirements for covered decks as opposed to an uncovered deck. The idea is that this existing deck is not in compliance, and adding a deck basically increases that degree of non-compliance. And so, any conditions that you may want to consider, I would say you may want to look at, how do we limit the increase of that non-compliance by, restricting the ability to, say, enclose it in the future, or that would be probably the main concern that we would have is, if we allow the roof, then it's very easy for somebody to come along later and put in glass walls around it, or whatever,
Right.
when they wouldn't
And that's
necessarily
what
have to
we're
get a
trying-
permit
yeah.
for that.
Like to avoid that. Okay. Any other questions for staff, guys?
I would suggest that we let the applicant respond to that if they want to.
Would you be amenable to a condition that says that you can never enclose it, screen it, or?
Yeah, sorry.
Thank you, Mr. McManus.
Yes, I would, but could I clarify? So we would never put glass screen. We're saying you would prevent us from ever being able to put a screen in there. It gets mosquitoes, so I'm just asking for our.
Yes, that
benefit.
would,
Okay.
if we, right now, what we're discussing is a condition that says that it could not ever, it has to remain just a roofed structure. No screening, no glass, no nothing.
Can I ask one other, because of the lighting, if we had like temporary shades?
Physical fixture. So I think we're allowed to put some kind of a, fixture or a shade on one side of the wall, but it still won't be considered as enclosed deck.
I think the condition would be permanent changes.
Yeah,
So
permanent
A
change.
rollable shade,
Yes.
if they get their way, a
Right.
rollable shade would be approved.
Right.
Yeah, we're amenable to that.
Or, the curtains that could be closed or whatever, that, but nothing permanently structured there.
Understood.
Okay,
Some motion
Mhm.
to approve
Oh.
was the condition.
all right, go ahead.
Before,
Solomon,
I
yes.
think we'd want to also say it would not enclosed, but made it into heated space too, just so that way.
Okay,
the
all right.
cover-
Yes, I totally agree with that. So say that again, Solomon, no,
That, because you guys said, no screening and it would not be made into heated space.
Permanent heated, because they might want to put a torpedo heater or something.
Yeah, well, yeah, I'm not talking, if they put a
not
fan or something.
permanently heated.
That's correct.
So let me, Mr.
McManus,
No,
Rishkov.
Riskoff.
Mr. Riskov. Yes, Mr. Riskov.
Yeah.
Are you a GC?
No, I'm just a contractor, but I do have a GC in my company and also engineer as a subcontractor. So
Has an engineer or a GC looked at the
yeah,
structure of
they
that deck?
did. They inspected and they've sent me a proposed roof construction with either it's going to be a stick frame or manufactured at the factory.
And
So
so,
they have that proposal.
and you're saying that
It's
there'd
safe.
be no changes to the support structure?
No,
Zero.
zero. It's already there. Foundation is 6 inches, concrete blocks under each column. Each column has 6x6 posts, installed and reinforced. All structures are not rotted. We inspected everything and it's in a good shape. So we're not doing any modifications to existing deck. Except
And you would need a permit for this roof, yeah?
Yeah, actually Mecklenburg County already issued a permit for that.
They did.
Yeah, they did.
Okay, so I would, if you get your way, I would say the condition should be that that foundation doesn't change either.
Okay. A change to the foundation. Okay. All right. No screening or enclosure. Okay. All right. Let me see if, Ms. Sun, if we can do this. If we decide to approve this, the condition would be there's no screening for this enclosure, no glass. So how do I say that to incorporate
No
all?
permanent walls.
No permanent walls. There we go. No walls. And the structure will not be cannot be permanently heated, and there will be no changes to the foundation to accommodate the roof.
Right.
Okay. All right. With that in mind,
Page.
Would your term walls include screening? Like,
Permanent walls, I think.
Permanent screening is.
well, we can say no screening or permanent walls. I mean, I think that, let's do that.
Walls are defined in the UDO. Walls, I forget what the actual definition is, but there's a definition for walls. How was it? I saw it.
Can't recite it? Come on, man.
I can't pull it from the 714 pages.
Well, it's okay. We could just say no screening or permanent walls.
Or you might, maybe a simpler way to be, the covered deck can only be outfitted with temporary wall systems. Screen. Which would like be rollers and
Covered deck can only be what? Deck can only be outfitted.
with temporary wall systems.
Does that work for you, John? Well, he said the covered deck can only be outfitted with temporary wall systems. Or Solomon looking up what walls mean.
Traditional building, because we call it structure. Have it on this.
Why don't you call it a permanent enclosure
Of-
or screen?
something like that, say permanent closure screening. And then,
Well, yeah, I'll get to the rest of it. So what we're saying is no permanent enclosure of the deck. Permanent enclosure. To include screening. Okay. All right. So we're gonna, if we permit this enclosure, there will be no permitted enclosure of the deck to include screening. The space may not be permanently heated, and there will be no change to the foundation when the deck is installed. Do you agree to those conditions, Mr. McManus?
Yes, we agree.
Okay. All right. All right. Now, Ms. Sun, if you would like to make your motion based on the three things we just discussed.
Down motion to approve the variance is the condition that there's no permanent enclosure and or screening and no conversion to heated space and no expansion or change to the foundation.
Very good.
Can we clarify that's both variances? That you
Those variances are
Yeah, that would, yeah, both variances would be approved. All right. So Ms. Sun has made that with conditions. Do I hear a second?
Williamson, second.
Thank you, Mr. Williamson. Okay. So everybody got the three conditions down? Do I need to say them again or we got them? You got them? Okay. All right. Mr. Williamson,
Williamson, yes.
to approve two variances. Mr. Court,
Court, no.
Mr. Shea,
Shay, no.
Ms. Sun,
yes.
and Dryden, yes. So the variance has been approved, 3-2.
Thank you.
All right, now, finding of facts and conclusions of law. Ugh.
Number 6.
Number 6, the hardship does result, okay. So for number 6, we're a result from exceeds the allowed encroachment to the rear yard. Stated, yeah, okay, the requested variance to allow the deck curtain degree. All right. Sorry.
Get to that legal counsel and.
Or what about number 10? Do we change that? The hardship does result from conditions that are peculiar to the property because of the tree stuff. I think we should.
Strike the word not.
Yeah, strike the word not. Record with an area, yes. The hardship. All right, the hardship does not result, number 12, from actions taken by the applicant. And we're going to strike because previous property owners built the home and the deck. All right, we're going to strike the rest of it. Actions of the current applicant would increase the degree of nonconformity. We're going to strike that part of the sentence. The requested variances are consistent, so we take out the word not.
Sorry, can you tell me which one we're on right now?
I'm sorry, that was 12. We took out the second half of the sentence, however, after however.
Okay.
And then for number 13, we're striking the word not.
In 12, we also insert the word not.
Yes, I'm
Hardship
sorry,
does
in
not.
12, yeah, their hardship does not result.
Okay.
Okay. I don't know, number 14, do we need number 14 anymore? At all? Since we've approved it?
That's just a statement of fact. isn't it?
So that's okay to leave, all right. Limited encouragement for unheated spaces to provide properties with the opportunities for structural setbacks. For the same standard, the existing deck already exceeds. All right, so what about number 15? I think after The purpose of the allowed limited encroachment for unheated space is to provide property owners with opportunities for structural unheated living space within setbacks. The 25% depth, 50% regulation is not new to the UDO. The legacy ordinance included the same standard. I think then we strike the rest of it. The existing deck already encroaches further to increase the encroachment of the UDO and other living space such as detached structures. I think it stops after the legacy zoning ordinance included the same standard, period. So the unnecessary hardship would, I'm conclusions of law now, the unnecessary hardship would result, the hardship does result, hardship does not, and the requested variances are consistent with the spirit such as public safety. Okay. And then adding the 3 conditions that we talked about. I don't know where you add that, at the beginning or at the end or what. Yeah, that's what we were just doing. But I don't know where you, anything else where else do you want to?
That's what you changed on.
I just said the last sentence, the existing deck already exceeds the allowed encroachment and the applicant's proposal would further increase the encroachment. I just struck that sentence.
You're leaving in the sentence UDO would allow other options?
No, no, we're taking that all out.
You may want to consider taking out that similar sentence then in number 11, with the last sentence in number 11. There's space for the lot for covered outdoor living spaces that does not create further extension.
Oh, okay. Yes, let's take that out then. Thank you. In number 11, we're striking. That's the last sentence.
For the addition of the condition, I would suggest adding it as a finding and a conclusion of law. So we would add an additional.
Oh, the
finding of fact.
condition. So we're adding a number 16?
Yes. Yes.
Okay. So number 16 will be the 3 conditions. Can I leave that to you guys to word, or you want me to say it?
I believe we're good on the, Crystal, you guys good on the conditions.
Okay. So we want to add those, yes, in the finding of facts and conclusions of law.
If you want us to read them out. as
If you
number
could,
16.
Yes.
You could, yes.
Number 16 would read that no permanent enclosure, including screening, would be made to the covered part of the deck. No permanent heating made to the deck, and no change in the foundation.
I would suggest adding a sentence right before those that says the variance is subject to the following conditions.
And that the applicant agreed to these conditions.
Maybe make that a new number 17. The applicant agreed to the
Well,
conditions.
can it just be in front of that 16? The applicant has agreed to
The following conditions. Okay.
Yeah, that's what usually happens. The applicant agreed to the, so that would lead number 16. The applicant has agreed to the following conditions. No permanent screening. Or no. Yeah, and no permanently heated space and no change to the foundation to accommodate the roof.
And then I would suggest we make that number 5 the conclusions of law as well. It would just read the same.
Instead of the applicant, a number 5 down at the bottom.
Correct.
Okay. So add it to the conclusions of law. Okay. As in 16. Okay. All right. Yay. All right. Now, do I hear a motion to accept the finding of facts and conclusions of law as amended and with conditions.
I'll make a motion to approve the finding of facts and conclusions of law as amended.
Okay. Do I hear a second?
So second.
Okay, thank you, Ms. Sun. All right, Mr. Williamson,
Williamson, yes.
Mr. Court,
Or no?
Mr. Shea,
Shay, no.
Dryden, yes, Ms. Sun. Okay. 3-2, they are approved. All right. Yes. Okay, we'll take our final break this morning for about 10 minutes, and then we will come back to hear the appeal. Where'd Buck go?
All right, I think we're ready to get started, board. This is case number appeal 2025-000112, appealing a zoning violation by Robbie Hodge, owner of property abutting the property located at 3026 Simpson Drive, parcel 093105112, owned by Miss Barbara Steffen. Again, appealing our zoning determination. This is the site. This is located, the vicinity map showing where the site is located in stars in red there. The current property zone N1C. This is exhibit number 2. And then this is the aerial showing, this is the house, accessory structure back here. What happened is, as part of this process, staff received a request to appeal the zoning determination made by the zoning administrator on a notice of violation. Code enforcement was currently in the process of closing out the violation, and an appeal to the zoning determination was made by the applicant. I'm kind of giving you a timeline. On 5/18/2025, code enforcement received a complaint from the applicant indicating that there was a structure that was built without the required building permits. Based on the aerial photos in Polaris, the structure was apparent in 2011. The city of Charlotte, obviously we don't have our permits going back that far. However, staff was, as part of the violation inspections, staff was able to determine that the pergola accessory structure was within the required side yard setback. The applicant provided a survey showing that there was a 3-foot encroachment, and it appears this was referencing the corner of the proposed pergola structure in the wall that was on 6/25/2025. A notice of violation was issued to the subject property owner citing the setback violation. And then on 7/17/2025, the subject property owner filed an appeal of the notice of violation. Once we received that request, staff met with the subject property owner who received the violation and discussed solutions for the pergola to become compliant and the violation to go away. The appeal was void since the subject property owner decided to remove the pergola portion of the accessory structure. On 9/23, a proposal was submitted by the subject property owner's contractor to remove the roof of the pergola, therefore no longer making it an accessory structure. And then on 10/25, which will show on reference in slide our exhibit of number 13, provided picture that the lattice fence was remaining after the roof and everything else was removed. At that time, it was determined that the fence it became a fence and it met the requirement of the height under the current UDO standards. And then on 12/29/2025, the applicant appealed the zoning administrator's determination. Going into here, obviously on exhibit 6, we have the non-conforming elements, but going in our general definitions here, I want to be clear, a fence is a structure, used as a boundary for screening, separations, means of privacy, protection, or confinement. An accessory structure, a structure located on the same site as a principal building that is incidental and subordinate to the function of the principal building. And then structure, we also have in the UDO in our definitions as anything constructed, installed, or portable, the use of which requires a location of parcel land. This includes a fixed or movable building, which can be used for residential, business, commercial, agricultural, or office purposes, either temporarily or permanently. Structures also include, not limited to swimming pools, to pools, tennis courts, signs, cisterns, sewage treatment sheds, docks, mooring areas, and other accessory construction. These are the standards in Article 17 of the UDO, which accessory structures. An accessory structure has to meet, the permitted in zone or allowed in zoning districts unless otherwise restricted by this article. And then it says on individual lots with a single-family duplex, triplex, or quadruplex, principal structure and accessory structure shall be located on the same principal as a lot. And then it says no accessory structure shall be constructed before the principal building receives a building permit or zoning use permit approval. And then a constructed accessory shall not be deemed to give authorization to a principal use not permitted in the zoning districts. The construction may be approved in conjunction with approval of the construction of the principal use, such accessory structure shall not be occupied until the permits for the principal structure are passed, closed, and a certificate of occupancy is obtained. Private docks and piers may be allowed prior to the structure in the neighborhood 1 zoning districts. And then it says a zoning use permit is required for all accessory structures except for those permanent structures that require building permit. In addition, certain accessory structures that do not qualify as permanent also require a zoning use permit. And then when you go to Article 17.2, it says standards for specific accessory structures, which where fences and walls fall in. And then it says neighborhood 1 zoning district standards. It says the following standards apply unless a different standard is required by the landscape regulations in Article 20. And this is a fence or wall located in the established front setback or a setback along a frontage shall be limited to a maximum height of 5 feet above grade. And then it's letter B, a fence or wall located in the established side setback between the established front setback and rear setback shall be limited to no maximum height of 6 feet above grade. And then it says C, a fence or wall located in the established rear setback shall be limited to a maximum height of 8 feet above grade. Going to our number 8, and then again, it was giving, kind of telling you what happened is on this one. What we're saying again, telling you that A and C are only applicable to the established front and rear setbacks. B, in this case, when we reviewed it, B is applicable to the subject site because the current structure or the current fence that's we're now calling it is in the side setback. This is the survey of the property, the home. There's a deck. You can see some items out here. And this in general is kind of the location of the prospect thing that we are now referring to as a fence after it was removed. And you could see here in 2011, when you could see this was the structure that was in question based on the definition of the UDO. This was a structure. And then in October of 2022, you can still see that obviously it was painted. It was still there. This structure here and the gate towards the backyard and some of the accessory structures of the rear. And then in February of 2026, you can see that the applicant to become compliant, when they receive the notice of violation, they completely remove the pergola structure, leaving this as the accessory structure, leaving this, which is now deemed a fence by the zoning administrator. On 10/20/25, the subject property owner who received the violation removed the pergola portion of the structure and the portion the fence that remained. The existing fence was reduced to 6 feet and meets the standards in the UDO for fences in the 17.2. Oh, we're going to go back to slide 5, based on the number 5. The applicant provided said it was 3 feet. That's a mistake. It's actually like 0.03. The fence encroaches on to the adjacent property. Again, here's the next picture. After the pergola accessory structure was removed, this is what's left. This lattice fence portion, obviously adjacent to the adjacent property of the fence. You can see right there in the rear. A fence, again, 17.2.D.2.B states a fence or wall located in the established side setback from the setback in the established rear shall be limited to a maximum height of 6 feet above grade. And when we went out there, this was meeting the 6 feet. This is the sign basic that we posted on the property. And then that is all we have.
Question. For clarity's sake, Solomon. If I understood that correctly, it said it meets UDO code?
Yes.
Everything meets code.
Okay. Well, I need to be clear. In relation to the violation that the property received, this meets code after the structure was removed, the accessory structure.
So I'm assuming that the applicant is going to say that there's something else attached to that piece right there? The existing pergola is still part of that?
The pergola's gone. They removed it, so it's completely gone. And then let me go back to, so you see, if you go out there today, that's what's there. So this is what in question, you can see it was attached to here and then it went over here down. All this in here has been removed and then the fence has been slimmed down into that final picture that you see right here.
I thought you said the roof was just removed, but
Well, when I say roof, going back here, it would be, I would classify this as the roof and then they cut this down here. So it's the roof and then this is gone over here inside.
So we're used to looking at things that are not in compliance. So what are we missing?
What are you missing?
Yeah.
Right. Are we looking at like, usually we're presented with something that's not in compliance and we're granting a variance?
Oh, I think you're not missing anything. I think what has happened is what his staff is showing it, and as me as being the administrator, is the applicant received a notice of violation from code. As part of the process, when a citizen in the city receives a violation, staff sits out and gives them their options. That you have an option, hey, you can come compliant through a variance, rezoning, or some other method to come compliant, such as obtaining a building permit, meeting all the requirements in the code. At that point, I believe the applicant, the property, I'm sorry, I say applicant, not the appellant, the property owner decided to remove it. And when they removed it and when code enforcement went out and inspected, we then did, and after we received these pictures, we deemed that this portion here is now a fence. It's no longer an accessory structure. It is a fence and it was compliant with the fence requirements. So we then said, hey, we are now going to start that process of removing that violation off, out of the system and out of her property.
Okay, you need
We
this
closed it out.
variance. You need this variance in order to remove the violation.
We don't need the variance. So what is happening is, as part of the appeal, the adjacent property owner is now appealing my determination that that this should be removed. And what we are saying is, this is a fence. It's meeting the requirements of the fence. The violation that was on the subject property owner it's meeting the requirements of the code. That violation now has gone away. And we are asking you either to make the determination of, you either uphold my determination or you then, the appellant, based on the decision for the appellant.
Force the owner to remove that piece.
I guess that would be, after that, that may be one option again, and that's whatever you guys decide. That subject property owner would then have to decide how they're going to handle it if you don't uphold my decision.
Right. That makes sense. Thank you.
so I assume that we have the property owner and the
Yeah, we want to get it.
That is correct. I believe that's correct.
both.
If they were, yes, so you will probably hear from the appellant and then we will hear from the property owner after.
All right, so who speaks next?
So
Thank you, Solomon. I have to swear you in, sir. All right, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
If you would state your name and spell it for the court reporter, please.
Robbie Hodge, ROBBIE, HODGE.
You can come right here. And then this little button can go through the
Okay.
slides.
Okay, Mr. Hodge, you are the owner of the property abutting the property at 3026 Simpson Drive, correct?
That's correct. I live at 3020 Simpson Drive, which abuts 3026.
All right, you may continue, sir.
And so I've filed this appeal for a compliance determination. Let's see. A structure was constructed in May of 2025 without a zoning permit that exceeded 12 feet in overall dimension. It documented an encroachment into my property. The zoning administrator issued a written compliance direction, which I will share on the next screen. This says that the lattice must be reduced to 6 feet, relocate the owner side to relocate the encroachment to the property side. And then, so we'll go here. So the original structure that was shown in the Google photos was actually dismantled in 2025. As you can see, based on the wood, a brand new pergola was rebuilt in May of 2025 that expanded the encroachment and expanded the width and dimension of the structure. To our knowledge, there was never a permit originally, so technically unlawful. The newest one was also created without a permit, even though it exceeded 12 feet in dimension. It was located in the rear setback as noted, and it did encroach into my property. It is integrated and adjoined to the fence and wall behind it. As you can see from this photo, they are linearly connected. Part of my original complaint was the overall structure, not just the pergola. Here were the key written directions by Solomon Fortune. You can read them, but basically they say reduce the lattice components on the side yard to 6 feet, relocate the structure on the side of the property owner side, complete the removal and construction process within the stated time frame. Currently, this is as of today, this is what exists. There's still an encroachment onto my property. There are still lattice walls that are well over the 6 feet requirement in place that are adjoined and linearly connected to the pergola structure. And then the photo in the bottom left is actually the photo I used when I made the complaint. There are roughly 11-foot tall walls with linens covering them across the entire rear side wall. Those still exist. The linens have fallen. They are connected still, but they do not spread the way you see them today.
I'm sorry, where are the lattice components that are 6 feet tall?
So I can just point.
More than 6 feet.
So both fences right here are 6 feet. These are lattice structures that are, well over 6. I don't have the exact measure, but this is the 6 foot grade here. And this is the same photo. So this is from an aerial. This is from the side. As you can see, our fences are now both at 6 feet, but there are structures that go above that. This is the documented encroachment. As you can see, we had it surveyed and marked relatively close to the pergola wall. As you can see, the pergola wall is over and encroaching. And we have 2 surveys, both mine and done by the resident. They match and mimic each other. One of my ideas here is that you can't reclassify a non-conforming structure that was never legally permitted. You can't, it's unlawful to just change it into a fence. It doesn't solve the encroachment issue that was already presented. And then also the city didn't mention, but they referenced a private civil agreement that was done in between both my property and the adjoining property. We did agree at one point to leave the previous structure in place. The second that structure was expanded and recreated, obviously that agreement civilly diminished. And it really should never impact UDO or have anything to do with zoning. It was an agreement between both parties. Ultimately, it cannot change the law and what size a pergola must be. So in conclusion, I'm just asking the board to determine the compliance of the original complaint that has not been achieved and remand for enforcement consistent with UDO and written zoning direction.
So clarification, if you can you go back to your picture of the properties?
Yes.
Yes, sir. So you're with everything being compliant now, the fence being 6 feet, the thing being removed, you're sitting here contesting. I just want to make sure I'm clear. You're contesting that structure in that bottom left picture?
Yes, part of my original complaint was an entire structure. There was a pergola and a linear fence that all sit within setback, that all are above 6 feet. The pergola has been adjusted. It is at 6 feet. It does still encroach the property line. But in current day, there are fences, linear structures, walls, I'm not sure how they would be determined, that are well above 6 feet within the 3 foot setback. And again, that was part of my original complaint. The pergola became the main focus, but ultimately, non-conforming structures in setback that are above 6 feet still remain. And I'm asking to, to reopen this and put a reconsideration that there cannot be structures above 6 feet in setback.
Now, the fence is what's encroaching on your property, but the figures in question that you say are above 6 feet, that's on their property,
That
correct?
is correct. They are within the 3-foot setback.
Okay.
But there is a post and a lattice fence that do encroach my property, which can be seen in this photo right here, and they were part of the pergola structure. So they have been built up as a pergola. I understand there was an attempt at reclassification as a fence, but from my perspective, a non-conforming structure cannot reach a reclassification because it should have never existed to begin with. If this was permitted or zoned, it would have never existed on my parcel.
I have a question for Solomon. So is this the right jurisdiction if there's an encroachment?
So I was obviously I was going to have to say, so when it comes to, so basically on a fence, when it's encroaching into the property owner, the staff, it's been city policy that we do not get involved when it becomes a civil matter between two property owners. And so what we were doing is we were basing it off of the violation that was handed to the property owner, and it was referring to the pergola and the accessory structure. So when we sat down with the property owner, it was to take care of the pergola, and we gave her several options. And obviously, the email that Mr. Hodges provided was a response to one of the options, because at one point, the applicant, Mr. Young, was talking about he wanted to put something to have vines or screens because they wanted to screen. The applicant was asking to screen both properties from each other. But then at this point, it appears when we went out for code enforcement, they just decided to cut it to a fence. So when it became now this is a part of it being deemed as a fence, this is now when someone is saying it's encroaching on my property, because like from our side, zoning wouldn't know, because again, there's not a permit required for a fence in residential districts. We wouldn't know that it's crossing a property line. And when Mr. Hodge and Mrs. Stefano say someone is saying that it's crossing the property line, we would then determine, hey, the violation has been met, because now code enforcement can close it out. But now that it's encroaching on his property owner, we would say that's now a civil matter between two property owners if Mr. Hodge feels that fence is on his property. And from his survey, it appears it is, but it's not for the zoning administrator and code enforcement to determine how you handle that based on that civil matter.
So his recourse is not here for encroachment, rather in small claims or district court.
Well, I think Mr. Hodge is asking you, the board, to say, hey, that the notice of violation should be reinstated, and that we should ask them to ask the subject property owner to then give them options, to say we would have to give them options. If you guys rule against me, we would have to give the subject property owner time to figure out how she's going to address that violation.
So he was saying that there are still structures above 6 feet tall. Is that correct or no? He was saying there are still structures that are above 6 feet tall.
So right now, based upon this, when you go off our findings of fact, or not our findings, our appeal, it would be those are accessory structures, and those, if they are not in the setback, we did not look at that based on the violation that was in. We were not looking at that. We were looking at the pergola structure that was completely out there. If there are now structures out there, we would have to look at what those were, because again, those were never presented to us as those are the issues. So again, I would then have to look at it to see what we would determine those are.
So just so I am perfectly clear and to simplify this as much as possible, Mr. Hodges is here specifically to address the fact that the pergola has been dismantled and is now being counted as a fence. He believes, I'll let you respond in a second. He believes that you misinterpreted the UDO and that that fence can't possibly be called a fence because the pergola was in violation to begin with. Correct?
So I don't want to speak for Mr. Hodge. I will say that is what we deemed it. And so I believe that is why we're here for the appeal.
Yes, I believe that a non-permitted structure that was unlawful to begin with cannot be converted or classified into a fence with an existing encroachment. And there is a written response from Solomon's Fortune that says it must be moved to meet compliance.
And so I think I need to respond to that in the sense of he has pulled an email that Mrs. Steffen and Mr. Young provided several options. And when I responded to say, because if you go to the previous email, there was a design, there was a design that they were talking about having screening going over. And that to me was going to be a structure. And I would say you have to move the fence or not, you would have to move that structure to meet the 3 feet. But when she cut it down and said, this is just a lattice on a fence, it was, this has now been deemed a fence. Because again, when we meet with staff, when someone has a violation, a notice of violation, we give all the options and we will respond. And we were responding, that EBO was responding to one of the options they provided.
I've got a question about the picture that you had where you pulled the tape out. And so what is the encroachment distance? I heard 3 feet, I heard 0.3 feet. Is it halfway on one property and halfway on the other property? Where's this fence lie?
So based on the survey, it's like 0.03, so like 3 inches.
So it splits the difference. So the post is halfway on one property and halfway on another property?
Based on the survey, the post is 0.3 into my property. So it fully exists on my property, 0.3 over, and then continues on.
So you own this fence. This is your fence now because it is on your property. It's not an encroachment because it didn't start on one property and just kind of move across. Like, staff, what is the definition of encroachment? Like, is it even, if you have a fence on your property and then it's on your property and it doesn't go onto their property, is that an encroachment or is that your property now?
The fence is diagonal, so portions of it do exist on my property. The post is solely on my property, but the lattice portions turn and
okay,
they are split. But the post itself is 100% on my property.
And I think for us as staff, as you can see here, that when now a property owner is saying, when we got our survey, it's hard for us to tell. And then at that point, once it became a fence, that's why we said it's now a civil matter between 2 property owners, and they need to figure out how they want to handle this. Because again, what's starting to happen is someone is asking government to be the arbiter of telling someone to remove something that we have, as a city, we have not governed. Because again, fences don't require a permit. All we have in the code is saying you have to meet this. And typically fences, being honest with you guys, it's complaint driven. If someone has built a fence, too tall or not in the right place, and then ultimately it becomes,
trees do the same thing. They jump right in the property line, and they like to be in the same terrible space.
So, but to Mr. Hodge's point, a pergola structure cannot be converted to fence. Is he correct?
Well, so here's, to be clear, it's the violation was for the pergola structure. And what happened was when we giving the option to the subject property owner, we stated, hey, if you take this down to a fence, it becomes a fence in the UDO. So for us, when it became a fence, when it was taken down, it became a fence. And now that's where it's now entered into, yes, fences can be on the property line. And now we have an issue between 2 property owners, and that becomes a civil matter.
And so
But the fence was lowered to 6 foot.
That is correct, based on the pictures that was in our exhibit.
Portions of the fence, as you can see, I mean, in this exhibit, and I wish they're a little bit bigger. That this is lower to 6 feet, but right connected to it linearly, these are all above 6 feet, and they're the same lattice structure.
was that a part of the original pergola structure?
They're linearly connected.
So staff, so the items that are being shown there that looks like there's growing structures on it, those are not those aren't in the setback. So I think that's where it's kind of like we're getting several things in here that's I guess what's happening on the property. And again, the notice of violation that someone is appealing is about in regards just to the pergola. if there are other things out there, again, we may have to sit down with the subject property owner and discuss that. But right now, based on this, when you go here to 17.2 standards for specific accessory structures, again, our specific accessory structures, it's basically saying that, it's basically we're saying in 17.2 that a fence or wall, where it's located in that established front, side, or rear setback. And then when you go to B, it says a fence or wall located in the side setback between the established front and the rear setback shall be limited to a maximum height of 6 feet above grade. And so this is where now we start going into the rear yard, and we would have to look at that because, again, it sounds like Mr. Hodge is saying from his side that there is something else back there in that backyard.
Do we have a second presentation before we get too far into talking?
Well, I think the subject property owner 3026, I believe they have asked to speak.
But I do want to clarify that this structure that we're looking at right here is aside from the violation that was put in place in the first place and what we're contesting now.
And I think we need to, I want to be clear for us as in speaking for code and myself as the administrator, we are talking about the pergola. I believe Mr. Hodges is saying there are other things out there. And that's where we need to be clear that what the documentation that Mrs. Steffen provided to us and what code that we had was based on the pergola structure that was there.
So what you're saying is that would be a separate case as opposed to what we're hearing today. The case of
from my determination,
structure right there.
So from my determination, that is correct.
Okay.
But I believe Mr. Hodges is giving his point of view, saying he disagrees, and I think that is why he's
Part of my original complaint remarked and noted these. The focus clearly became on the pergola. It encroached. It had the largest volume. That was where the focus was. But ultimately, these structures were part of the original complaint. They sit within a setback. They are above 6 feet, and it is part of my complaint. And closing the complaint with these structures in place just doesn't make sense, which is why I'm appealing that.
Can I ask a clarifying question? For an appeal, there has to have been a written determination, and the zoning administrator's position, like, has there been a written determination as to these items that are on the screen right now?
No, there has not.
Okay, so just a
So
written
right now,
determination about the pergola.
That is correct.
Okay. Thank you.
Okay, anything else, Mr. Hodges?
Yep, thank you for your time.
Oh, I appreciate it. Thank you very much. All right, so we have the property owner who would like to speak. I'm assuming.
I'll speak on behalf of Ms.
Okay, just make sure, because if she's got us talk, she's got to come in. All right, sir, I need to swear you in. Swear you in. Please place your hand on the Bible, please. And do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, I need each of you to say your name and spell it for the court reporter, please.
James Young, Jamesyoung.
Barbara Steffen, Barbarsteffen.
All right, Mr. Young.
Pull this up for you, sir. You just scroll this.
Sure. Okay. I think so. I don't really want to waste too much time because I think Solomon and everybody else has covered it. And it's pretty cut and dry, but it has been removed, and it was more of a landscape support than anything else. I mean, it was just to directionally grow vines that were clematis from one side to the other, and that was it. And it was constructed by 2x4s that on the second one that was built in 2025. We've seen that picture already. So this side fence, which was installed in 2010, this is before any of the landscape support or accessory structure that was termed later, was already built. It was actually built inside a chain link fence that went around Miss Steffen's property when she bought it back in 1995. And that wooden fence was installed inside of that chain link fence. Now, when they built Mr. Hodges' house, the builder tore out that chain link fence. And so there was no chain link fence anymore. that nothing has been moved since 2010. Later, in 2011, they added this on top of that fence, which is y'all call an accessory structure. Now, this one obviously is in a very dilapidated state. It's been around since 2011, and no one ever called to complain about it, not even Mr. Hodge. This one was clearly above 12 feet with the spire on the top. So, as a surprise for her birthday, her brother rehabilitated the pergola to A, make it safer. To make it safer for everybody. It was lower in height, under 12. There was nothing here that's over 12 feet in dimension. And that was confirmed by code enforcement that came out and measured it. It's even further west of the property that Mr. and Mrs. Hodges own. So that overhang on the right is about 3 inches less than what the old one was. So design-wise, it's the same, but it is a smaller structure without the spire on the top and shorter in width. And obviously safer. So and that's the intention of it. So that's why I call it a landscape support. It would be like putting a piece of bamboo on a tree or pantyhose on a tomato vine to grow it in a certain direction, just to angle the growth. And it was beautiful when it was up. And that's what it was designed for. This was really something else there, but I think we need to clarify that it's always been a fence. It just had that 2x4 structure put on top strictly for landscape purposes, and that's it. The new one that was, or the rehabilitated version in 2025, which has sparked this barrage of new complaints, was less in all dimensions and definitely over 12 feet. So I don't think there was any ill intent of putting it up. It was simply just a really nice aesthetic, pleasing landscape support. Nonetheless, this particular case has been opened and closed 2 or 3 times. And out of sheer frustration, Ms. Stephan just took it down. I don't blame her. I would have done the same thing. I wouldn't want to handle it anymore. And so what was left was the fence, and it was, and always was since it was built, over 6 feet tall. And so in order to comply with that, we took it down below the height of the Hodges fence. So if we're out of compliance, then he's out of compliance. Now, there's nothing else that Ms. Stephan ever knew other than that particular pergola incident. All these other pictures we see at the bottom, that's news. I mean, if it's something that we need to address later, no problem. But this would be the 15th complaint since they moved in 2020. Prior to that, she's lived there from 1995 to 2020. These are all the people that have occupied that land. That's a pretty big difference. 0 complaints, and all of a sudden, 15, and 1 even on animal control. There's a list of all the complaints. 11 of the 15. Now, the 15th one, I haven't seen a resolution on it other than it's the code, so I'm assuming that's owner compliance. 11 out of 14 have been dismissed. That's a lot. It's a lot for someone to handle. This is kind of subjective, but I think it speaks to it. This is a very eclectic yard and house, an old style, 1954. Its estimated value is $416. It's a 2-bedroom, 1-bath, 1,000 square feet. This is Mr. Hodges and Heather's home, 1.24 million, 4 beds, 4 baths, 3145. Maybe this doesn't just jive with the groove when they moved in. Now, prior to all this in 2022, and the reason why we really shouldn't even be here, these 2
neighbors engaged in a mediation agreement. That was recommended by code enforcement for some really interesting issues in 2022. And they came up with several agreements, and they're included in these. And one in particular is this 0.3 foot encroachment. And basically the parties agree that Mrs. Stephan's fence corner encroaches 0.3 feet. It's the length of this business card. The properties agree that the Hodges may move the encroaching portion of the fence as agreed and determined in consultation with the surveyors at the Hodges' expense. It would seem to me that this last complaint is he's trying to get out of that. Now, also in this, and he showed a picture of the asphalt driveway, and the surveys from one to the other, Mr. Hodges and Barb's are pretty much clear. They're about the same. I don't think there was any ill intent in the beginning in 1997 when that asphalt driveway was put in. Nothing's been added, nothing's been amended to it. Has it flattened out? It possibly has. And maybe it's encroaching on someone else's property or Mr. Hodges' property. That's very possible. But as you can see in the top paragraph, Ms. Stephan's asphalt driveway encroaches upon the Hodges property at 1.2 feet. It's listed on the other, and it's all for a section of a couple feet that crosses over that line. Now, the most important part and why we shouldn't be here is that this last clause right here, and without being, I'm not a lawyer, but this is more or less an estoppel clause. It's saying all these things that you have agreed to in this document, the Hodges can't call in code enforcement about it. So they are essentially stopped from doing that. And they breached that clause, and that will be addressed on another matter. So everybody I've dealt with at code enforcement, and Ms. Stephan has been professional, respectful, and very neutral. There's no sides ever taken. And they are very clear in their directions of what can and cannot be done. And Ms. Stephan has worked with them well, and you worked with Ms. Stephan in the fact of explaining everything in great detail. And I feel for you. I feel for Ms. Stephan. This is why I'm speaking for her. I've been a friend of hers for 25 years. And now I am a neighbor of that neighborhood, or included in the neighborhood. Y'all have any questions? That was the end of the slide. Oh, I do have one more thing to add. Getting back to Mr. Solomon's statement about the original email he sent Robbie saying that they have to move, you need to move that fence portion that encroaches onto the land, as if he was telling that to Mr. Hodge. And that was in response to an email that Barb and I had sent saying, well, if we can't have the pergola anymore or the landscape structure, what could we do to still keep a landscape structure so that her vines could grow? So Mr. Solomon said, well, if it's an accessory structure and it's still going to be under X amount of feet, you have to pull it off the neighboring property, or it has to be a 3-foot setback. That's what he was referring to. So if you want to build this newer thing that meets all the code requirements, you're going to have to move that section of fence, which the pergola stood on, away, or build an entirely another one that it rests on from one side to the other. And that's my interpretation of what he was stating. I mean, I think we might be in agreement on that.
May I ask you, this picture that you're showing?
Yes.
On the left is the lattice structure?
This is the lattice structure that is closest to Barb's house.
And how tall is that?
I think it's about 9 feet. Now, this is obviously some 11 feet away off the property line. And originally that was there because she was growing rose bushes that would crawl up the side of that one alone. That wasn't anything it was just a decorative landscape support for the rose bushes. And that's not really attached to any fence. It's a standalone. But this all the way down is attached to the front gate fence. And that was built 2010 before the pergola was added.
So in clarifying that, you said it's your position that that was constructed as a fence first?
Yes. I mean, it's attached to the fence and to the wooden fence that's over here and to the gate in the front. And it followed the same line as the chain link fence. It was inside of it. There was a chain link fence in the front too as well.
And how tall is that fence?
Oh, it's under 6 feet. It's under that height that I showed you.
All right, any other questions for Mr. Young?
Right. I hate to see neighbors not get along. It bugs me to no end, but this has been going on since 2020.
Yes, sir.
And there have been multiple meetings between Mr. Hodge and your friend since then.
Correct.
And culminating might be the wrong word, but in your opinion, culminating with the mediation agreement in 2022.
Yes.
And then the 15 complaints started in 22 or 20?
2020.
2020. So
yeah, there's a list of all the dates of which this occurred. And I'm going by your information, so I'm not making it up. It's these are your requests. And right here, you can see it starts a couple months after they move in and pretty much to June 25th.
Yeah, I don't want to go into left field by myself here without a glove and a mitt and so forth, but I mean, it's off of the decision we have to make. But I'm trying to understand if there's something that the board can help with to bring this so that people can sleep at night and not have to worry.
Sure.
It's got to suck.
Unfortunately, I don't think that can happen. The board can only make a decision on the appeal.
Yeah, really treat that. We're not.
I'm not sure I agree with that, but
I mean, there's no ill will. I mean, and I remember Barb saying to me when the Hodges moved in that Mrs. Hodge came over and complimented Barb on her lawn before they moved in, saying that Heather's mother really thought that Barb had a beautiful looking lawn. And Barb called me and she goes, "You'll never guess I had the greatest neighbors moving in. They love my yard." And then, boom. And I think they've tried to work through it a little bit, both of them. But I think the end result speaks for itself. I mean, this is just data. I mean, I go by objective data. I don't try to do anything subjective. I don't want to waste anyone's time. I generally deal in science-related things, so.
Thank you, Mr. Young. Any other questions for Mr. Young? Any other statements you'd like to make?
No, ma'am. Thank you for having us.
Thank you very much. Appreciate it.
Mr. Shea, you can affirm wholly or partly or modify the determination, but that is the extent to which the board can do. I'm just in regards to your statement about what the board is able to do.
We modify or reverse.
I'm not talking about making a legal application. I'm not suggesting that at all. I'm suggesting that the board might have some sway in this that would bury the hatchet so that Mr. Hodge and his neighbor could get along. Whether that's legal or not, I'm just speaking like a human. That's all. Bugs the crap out of me.
Yeah.
Yes.
Mediation was for, I thought. That's why we agreed on all this. And he just keeps incessantly calling me in on ridiculous stuff like grass clippings, weeds tall in my yard. I don't have weeds in my yard. I have only flowers. Everybody stops by my yard and tells me how beautiful it is. I don't have that riveting a life. I go to work and I come home and want to work in my yard, and that's all I do. And I don't understand why I'm getting terrorized for no reason when I've never had a problem. No one ever, with all the people that live next to me, have ever mentioned anything about a property line. The builder that built that house never mentioned anything about a property line. He didn't say anything about it. They never got a survey when they first moved in. So I would never have known any of this. My ex-husband, who works for the government, put that, and he's a civil engineer. He put that asphalt driveway in. So I know it's perfect, what it was. But over time, things, the heat here and everything, it's like I didn't do anything intentional to do anything to anybody. I just like to mind my own business and be in my own yard and do my own thing. So,
Thank you very much. Thank you, Ms. Steffen. All right. To clarify for the board, within our purview, as a zoning board of adjustment. We must decide if Mr. Hodges is appealing, Mr. Hodge, I apologize, is appealing the zoning violation determination. But the zoning determination was that the property owner is now in compliance. They have removed the pergola, which was the contention, and they have lowered the fence size to 6 feet. We can't deal with the 0.3 inches because it's not within the zoning ordinance for them to do so. If the houses have been together as long as they have, it seems to me rather petty to squabble over 0.3 feet, but to each his own. So that's what we have. We need to either affirm the zoning administrator's determination that the violation has been corrected, or we have to say it's not been corrected. So we would not approve the zoning administrator's determination. So I will entertain thoughts.
Mr. Ryan, before we move on
Yes.
to discussion really quick, I just want to make sure that there's not any rebuttal.
Oh,
that's been
okay.
Put on.
Anybody have, Mr. Hodge, zoning, anybody else have anything else to contribute before we start discussing this? I want to give everybody a chance to have your say.
I think what we just want to say is we, code enforcement officers, we've all tried to act professional, dealing with both sides, being fair and making sure that we are, not taking on one side of each other. I think we've just, in regards to when I reviewed it, it was basically reviewing it based off the facts of the pictures of what was out when Mr. Young or whoever did the construction had taken it down. And that's where we came with our determination. And so at that point, as part of our process, when a citizen in this city does receive a violation, staff is always trying to work for the positive outcome, because as you know, once we drop the hammer, the stick I have, I like to say it damages relationships and it gives people that bad taste of government once we've dropped it on them. And ultimately, like I said, and I know sometimes when people say it feels like this process takes a long time, it's because, again, both sides have rights, and I'm making sure that staff is respecting both sides as part of this process.
But your determination was that the fence was part of the pergola, but when the pergola was taken down and the fence itself was shortened to 6 feet, that then satisfied the removal of the pergola, and now we have a fence.
That is correct. And it appeared that fences had been, that when you tried to go back, you saw some fences are there, and then that is correct. That we determined it was a fence. And then as we've stated in our position, if it was crossing over property line, it then becomes a civil matter between two property owners.
Okay. All right. Thank you, Mr. Sullivan. All right.
I also just wanted to clarify for the record, the slide that we continually referred to in Mr. Hodges' presentation, can we note for the record which slide that was? That had the pictures. It was this one. Which is that slide?
Slide
5.
5.
Okay, slide 5 of his presentation, just for the record. Thank you.
Okay, thank you. Okay.
The reason I put those sun sails up, they're not just sheets or anything. I bought nice sun sails because they leave their pool lights and their pool house lights and their TV in the pool house. Everything's on, and it comes all into my backyard. And it's almost like I could land a plane with the light. And that's why I put that up, because it comes right into my bedroom window. And it's on 24/7. Never goes off. Maybe an hour or two at like 5 in the morning. I don't know, but it's on all night long. And I think that's a waste of energy, personally. Thank you.
That's not in our purview to determine. Thank you. All right. Anybody else have anything else to say? All right. Thank you, Mr. Hodge. Thank you, Ms. Steffen. Thank you, Mr. Young. All right, board, we are now in deliberations.
All right. I will say, based on everything I have seen, the evidence I have heard, And understanding, having close relationships with the staff and a lot of departments. Staff works at a fiduciary duty. I think the property owner has worked in good faith. There have been numerous violations. They worked in good faith to curb those violations. They've finally been curbed by code enforcement. I don't think staff will rule one way or the other that's favorable. They aren't elected officials where they have benefit. So I would keep what code enforcement has ruled in place.
All right, thank you, Mr. Young. Mr. Court, thoughts?
I would be inclined to reaffirm the administrator's determination. The moving into a neighborhood or just building a house in a neighborhood requires some adjustment and some patience and grace with the folks that you're around. And there's got to be some give and take amongst everyone. It's not a zero-sum game. And I think that the zoning administrators have looked at this case, and they have taken what has been presented to them and worked with the property owner to bring what has been presented to them within compliance. And I don't see any error in what they've done.
Okay, thank you. Ms. Sun, what are your thoughts?
Kevin.
I know, I'm gonna go to you first, though.
Okay, I think I would deny the appeal because encroachment is outside our jurisdiction as board for zoning.
Okay. All right, Mr. Shea. I said best for last. That's me.
I think Mr. Hodge was talking about the fact, and I don't even know if that was determined or not, but he was talking about the fact that the pergola was illegal to begin with and then was converted to a fence, and you can't do that. According to Mr. Young's testimony, it was always a fence and a pergola grew out of that. I don't know what the truth is, what the history is. It's irrelevant to me. The bottom line is that it looks like a fence. So if it quacks like a duck and it walks like a duck, it's a fence to me. So I would confirm that Solomon's decision is correct.
Okay. I agree with the statements that have been made here today. I know it's terrible when neighbors don't get along. Looking at the mediation reports and the things that were agreed to, in my opinion, it is time to lay this to rest. The pergola's been removed and the fence was shortened, and if the fence was always there, like Mr. Shea said, we have no way of knowing that. I'll have to take everybody at their word. But if zoning has gone out there and determined that this is now a fence according to our UDO, and it's lowered to 6 foot, then I am inclined to uphold the zoning administrator's determination and close this case. So do I have a motion?
Yes, I make a motion to deny the appeal.
So second.
And can we confirm that that means we're upholding the decision of the
Yes,
zoning?
yeah, let's say it that way, Mr. Young, that
I make a motion to uphold the zoning administrator's decision.
Okay, Mr. Young and Ms. Sun to uphold. Okay, Mr. Young?
Young, yes.
To uphold.
Yes.
Mr. Court?
Court, yes.
Mr. Shea?
Shea, yes.
Ms. Sun?
Yes.
And Dryden says yes. So we are upholding the administrator's determination to close this case. All right, looking at the finding of facts and conclusions of law.
Motion to approve.
Second.
All right, Mr. Shea, Ms. Sun, Mr. Young,
Young, yes.
Mr. Court,
Court, yes.
Shea,
yes.
Ms. Sun, I'm sorry, and Dryden, yes. So the finding of facts and conclusions of law. Okay. Thank you very much for participating in this civil exercise. And I hope you guys can work things out. All right, we have one more agenda item really quick. we have to approve the minutes. So from last time, so if you'll look those over, please. Okay, do I hear a motion to approve the minutes from the January 27th meeting?
A motion to approve.
All right, Ms. Sun has a motion to approve. Do I hear a second?
Young second.
Hey, Mr. Young. Mr. Young? Yes?
Young, yes.
Mr. Court?
Court, yes.
Mr. Shea?
Yes.
Ms. Sun?
So yes.
And Dryden, yes. So the minutes from the January 27th meeting of the board are approved. Thank you very much. This meeting is now adjourned.